contractors?
No.
Your Honor, I would move to admit Dakota Cross Exhibit 5.
I'd object. I don't see the relevance. Has nothing to do with the witness's testimony.
Your Honor, the witness is talking about the case. We're certainly able to use his own statements in cross-exam. We've talked about the fact that he clarifies that he is a fact witness, not an expert witness, in this interview, and we're just providing the transcript. I think it's relevant. It certainly is more relevant being the witness's own words, and there's better foundation since the witness recognized it than many of these just random trade press articles that have been admitted in the last 2 weeks.
Mr. Taylor, you're overruled. Dakota Access Cross Exhibit 5 is admitted.
Thank you. Mr. Swenson, in your testimony, you discuss as an example of how you do an implant study, some work that you did for the Red Rock Hydro Project. Is that correct?
Yes.
And that would be a study titled The Regional Economic Impact of the Red Rock Hydroelectric Project?
Yes. Yes.
Your Honor, if we could have distributed Dakota Access Exhibit 6. And Mr. Swenson, would you agree that this is a true and correct copy of your study on the Red Rock Hydro Project?
It is the study.
I'm sorry, what was it?
Yes, it's the study.
Thank you. Your Honor, I would move to admit Dakota Access 6.
Mr. Taylor?
At this point, I don't see the relevance. I understand it's a study he did, but I don't see the relevance.
Your Honor,
At
in
this point.
Mr.
If
Swenson's...
you're going to use this as part of your cross-examination, why don't you do that, and then we'll make a decision on the admission after you've...
Your Honor, I will make my point now. I'm actually not going to ask any further questions about it. Mr. Swenson, in his testimony, talks about it somewhat extensively and talks about how he did some things that are different than how he believed SEG did them. But then they didn't attach the exhibit, which I understand it was a little different setup from Mr. Swenson's testimony. I could get into that, but I won't. But for context and completeness, since he talks about it as an example, we believe that it should be part of the record and should be usable in the record. The door is clearly opened by Mr. Swenson's testimony. I think it would be problematic to let him talk about the parts he wants of the study and then not have the study be part of the record.
So, Mr. Dublinski, for the record, just point to 2 or 3 of the places in the testimony for the board.
Yeah, he talks about it at page 17. And it goes on from there, where he talks about how he would show, for example, jobs data and broken down over years, starting at 17 and going forward. Talks about the example of the Red Rock Hydro Plant. Candidly, Your Honor, I've been objecting to people reading from a document into the record when the document speaks for itself. We're trying not to do that and to save time. Again, the document speaks for itself. He's opened the door for it. We think it should come in. People can brief it from there, but otherwise it's just going to be reading from the document, which
I just simply wanted you to
Yeah,
point out
yeah.
for the record where the information was. I'm going to allow it to be admitted, Mr. Taylor. Do you have anything that you want to state for the record?
No.
Dakota Access Cross 6 is admitted.
Mr. Swenson, you have, let me back up. Is it fair to say that you have spoken over the past year or so with numerous media outlets about this project?
Maybe 3
Okay.
interviews.
Do you recall giving comments to the Ames Tribune about this time last year, 2014?
Yes, I do.
And in those, I believe that you said, or in fairness, at least you were quoted by the Ames Tribune as saying that there would be no sales or use tax revenue on this project. Is that correct?
Indeed, I said that.
And in fact, you've since corrected that statement and said that is not correct.
I said that was not correct, and I also sent a letter of correction to the Ames Tribune.
Okay. I appreciate that, Mr. Swenson. You also, again, about late November of 2014, had some comments in a Newton Daily News article about the approaching county information meeting on the project. Do you recall that?
Mhm.
Can we
Yes.
distribute Dakota Access Cross Exhibit 7? And Mr. Swenson, if I could call your attention to the last page of that document, work backwards here. Those first 2 paragraphs on that last page either quote or paraphrase information that you had provided the reporter. Is that correct?
Yes,
And in particular, that second paragraph, you're talking about the issue of property tax revenue for the state, correct?
correct.
And if we go back one page from that on a section there that's titled Economic Impact, in the middle of that, there's a paragraph that starts, but Iowa State University. Do you see that?
Yeah, I see it.
And that goes on to talk about the impacts of farmability and restoration of the land, correct?
Correct.
Your Honor, we would move Dakota Access Cross 7.
No objection.
Cross 7 is Dakota Access Cross-Examination Exhibit 7 is admitted.
Your Honor, we have no further questions for this witness.
Mr. Pauly,
No questions.
Ms. Jacobs,
I have no questions.
Mr. Wagner, Mr. Taylor,
I have no questions.
Mr. Swenson, you may step down. Thank you. Mr. Taylor, you may call your next witness.
We call Dr. John Doershuk.
Mr. Doershuk, please raise your right arm. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
You may be seated. Mr. Taylor,
Thank you. You state your name, please.
John Doershuk.
Have you previously submitted pre-filed written testimony and exhibits in this case that have been admitted into the record?
I have.
Do you have any additions or corrections to that pre-filed testimony?
Yes.
And is that the statement that is now been filed as Sierra Club Hearing Exhibit 33?
Yes.
We'd offer Exhibit 33 into evidence. I think the board has already ruled that it's being admitted.
at this time, Mr. Dubinsky, you have the opportunity to make any Ms. Agramonte, you have the opportunity to make any statement of objection as it relates to the offer of admission for hearing exhibit 33 by Mr. Doershuk.
Thank you, Chair. Dakota Access renews the objections that it made previously for this exhibit that is not compliant with the board's scheduling order or processes in this proceeding, and we believe it does cover old ground and shouldn't be admitted, but we understand that the board has made its determination.
Thank you. Mr. Taylor?
My understanding was from the board's previous order was it would be admitted, but that Dakota Access would have the opportunity to present a rebuttal testimony concerning the information in Exhibit 33.
That is correct. Mr. Lozier?
We have no questions.
Mr. Piazza? Ms. Agramonte?
Thank you, Your Honor. I do have some questions. Good afternoon. I believe we're in the afternoon, Dr. Doershuk.
We are.
Are you currently employed as the state archaeologist and director of the Office of State Archaeologist?
Correct.
Your employer is the University of Iowa.
Correct.
Are you providing testimony in support of the Sierra Club for the University of Iowa?
I am presenting information as required by my position definition in the state code.
You're required to provide testimony in support of a party in a proceeding before the IUB?
I was invited by the Sierra Club to provide information, and I took advantage of that opportunity for Mr. Taylor to handle some of the logistical aspects of this. But it's not testimony on behalf of the Sierra Club or, in fact, pro or con for this pipeline.
Let's talk a little bit about the Sierra Club. How were you invited to provide information?
Mr. Taylor contacted me.
When did Mr. Taylor contact you?
I don't know the exact date. It would have been October-ish of this year.
What did Mr. Taylor say to you when he called to invite you to participate?
He indicated he was aware that I had filed a letter of comment earlier in the year and asked if I had planned to appear before this hearing. And I indicated that I was undecided, and in part because I didn't know the procedural aspects of doing so. And he indicated that he could assist with a more detailed written document being presented to the board than I had prepared earlier in the year, and did so.
let's talk about that more detailed written comment. Are you referring to your testimony?
Yes, that I think was filed October 12th. I
Who
believe.
drafted that?
I drafted the initial document. Mr. Taylor looked at it, made some comments, and I refined some of my answers accordingly.
What answers did you refine?
I couldn't tell you the specifics at this point.
Can you tell me how many you refined in response to Mr. Taylor's suggestions?
I had edits throughout the document.
After you submitted your letter in May of 14, is that the right date roughly?
I think so, yeah.
Did you contact anyone at the IUB to ask to participate in this proceeding?
No.
Do you think it's unusual for a state representative to be called by a party in a contested proceeding like this?
I have no idea.
Are you being paid to be here today?
I'm employed, yes.
Is the Sierra Club providing you any additional compensation?
No, they are not.
Were you subpoenaed?
No.
Are you going to be charging the University of Iowa for your time here today?
I have the discretion in my position to invest my time as I see fit in the promotion of the duties of my office. So, yes, I will get a paycheck for my activities today.
Just to be clear, you are here in your official capacity
Yes, as state archaeologist.
on the clock.
Yes.
Did you meet with Mr. Taylor in preparation for your testimony today?
I have not met with Mr. Taylor since October when the written testimony was developed.
Are there any agreements between the University of Iowa and the Sierra Club regarding your testimony or this proceeding?
No.
You are aware that the Sierra Club has taken a position in this proceeding against the project?
I am now. I wasn't before.
Have you read any other materials in this proceeding, either testimony or documents that have been provided?
The rebuttal testimony of Monica Howard to mine, I looked at. I've seen, as I indicated in my follow-up statement, reporting that, I don't know if those are part of the record or not, that the archaeological consultant that Dakota Access has employed. But no other.
You testified just a few minutes ago that the state archaeologist was not taking a position on this project, yet I informed you that the Sierra Club is opposing this project. Do you think it's still appropriate for you to provide testimony on behalf of the Sierra Club?
I'm providing testimony on behalf of the state of Iowa.
I'm noting here that the sign up for your testimony is that you're a Sierra Club witness. Are you disputing that?
No.
Nobody asked you here from the IUB to provide testimony in your official capacity, isn't that right?
Correct.
Have you ever been asked by the IUB to testify in your official capacity?
No.
Have you ever testified in another contested case proceeding in the state of Iowa regarding a proposal?
An IUB?
Any agency?
Yes.
What are those agencies?
The Department of Transportation, Corps of Engineers, Department of Natural Resources. My office is engaged continuously in discussions, conversations, negotiations concerning preservation of cultural resources.
Yeah, my question was a little bit narrower. You understand this is a contested case hearing today where you're providing testimony, right?
Yes.
And have you been in other contested case
No,
proceedings?
I'm sorry, no.
This is your very first one?
Yes.
Did you have to obtain any approval from anybody at the University of Iowa to provide this testimony?
No. Maybe I can clarify a little bit. The Office of the State Archaeologist is a relatively unique organization in as much as it is code mandated, but was intentionally placed as a research center at the University of Iowa. So I wear two hats in a sense of a state agency official, but embedded at the university.
You're not authorized to provide any testimony on behalf of the Iowa State Historic Preservation Office, are you?
Not specifically.
You have no official capacity. You're not here to
Oh, correct.
represent
No,
them.
no.
And no one from SHPO has provided any testimony in this case, have they?
I'm not aware of any.
And you're not authorized to speak on behalf of the U.S. Army Corps of Engineers?
No.
No one from the U.S. Army Corps of Engineers has provided comments in this docket either that you're aware of, isn't
Not
that
that
right?
I'm aware of.
Let's turn to the Office of the State Archaeologist. You are not a regulator, right?
I have code mandated responsibility for ancient human remains. That's the only legal definition I think that I would have some authority under.
Yeah, but isn't it true you have made statements providing very clearly that the state archaeologist doesn't have a regulatory function?
Except for that very narrow issue, yes.
Right? You don't issue any permits?
No.
The Office of the State Archaeologist also has no authority or responsibility to review or approve survey protocols for cultural resource surveys in the state. True. State, isn't that also correct?
Under the, I think the responsibilities that define the office would be readily interpreted to say that we have to participate in those discussions.
Let's
And
take
we-
a look at Chapter 263B. That
Sure,
would be the
yeah.
statute, right?
Mhm.
I have forgotten where Mr. Dublinsky left off. What number are we on for cross-examination exhibits? Thank you. Thank you. Mr. Doershuk, Exhibit 8 is Chapter 263B. That's the authority under which you operate, right?
Correct.
Can you tell me where in here it provides you authority to review survey protocols?
Well, I would look at 263B2 duties. State archaeologists shall have the primary responsibility for discovery, location, and excavation of archaeological sites, and for the recovery, restoration, and preservation of archaeological remains in and for the state of Iowa, and shall coordinate all such activities, so on and so forth. So it's really that responsibility and coordination activity for archaeology in the state.
I don't see anything in there about approving survey protocols. Are you
doesn't-
saying it does?
It doesn't say that in so many words, no.
Move admission of Exhibit 8.
Hearing no objection, Exhibit 8 is admitted.
No objection.
Another follow-up question about this chapter. There's a specific provision in here about how you work with the Department of Transportation, and
Yes.
indeed you've made a couple of references about that, right?
Mhm.
So there are specific provisions about how the Office of the State Archaeologist is to coordinate on road projects,
Yes.
and there's nothing in here that's similar regarding hazardous liquids pipelines, right?
No, this document was created in 1959 at a time before the National Historic Preservation Act was even passed. And so the roots of this are that the State Department of Transportation in the late 1950s, early 1960s was the only entity that was really engaging in the kinds of activities that now are commonplace for all federal agencies complying with the National Historic Preservation Act. So its roots are in that relationship. It's never been updated.
This statute also doesn't provide for any requirement on behalf of project proponents to consult with your office, does it?
No, there is no legal requirement to do so. Although I guess the one exception would be in the case of human remains.
And we'll get to those right now,
Okay.
because I believe that you had some comments in your updated testimony, and then also to make a clarification that the office that you are in charge of would only have responsibility for ancient remains, which under the statute are 150 years old or older, right?
Correct. It's a rolling date.
You would anticipate that that responsibility would arise during construction, not pre-construction. Wouldn't that be correct?
Depending on the results of field sampling surveys, they could be discovered in the pre-construction activities or certainly during earth moving during construction.
Is part of what the Office of the State Archaeologist do is pursue grants and contracts to allow the office to do research?
Yes.
And this allows you and those in your office to sell services regarding cultural resource management to third parties for a fee, right?
Yes, I don't participate in that aspect of it. I have a research director that handles those activities.
In fact, your website markets these services, is that correct?
Correct.
How does the Office of the State Archaeologist establish fees for consultant work?
It's essentially straight labor based on the position descriptions of the employees in the office through the university payment structure. So it's a time and expense type of consulting activity.
Do you, as you sit here today, know what the last 5 consulting jobs were that the Office of the State Archaeologist undertook for third parties?
The last 5. There's probably 20 or 30 ongoing projects right now, so I'm not sure how we define the last 5.
Well, let me ask it a different way. You have an annual budget, right?
Yes.
How much of your budget is funded by these third-party contract activities?
Roughly 80%.
Are you familiar with the work of Bear Creek Archaeology?
Mm-hmm.
Yeah, I realized a couple of times you've either said mm-hmm or huh. If you could say
Yes.
yes or no, that'd be helpful for the court reporter. Thank
Yes.
you. So Bear Creek Archaeology, they're out of Cresco, Iowa, right?
Yes.
And are you aware that that consultant worked on the Dakota Access pipeline?
Yes.
And they primarily conducted the probability modeling, including the geomorphological assessment for the
Yes.
route?
Yes.
And are you also aware that Burns and McDonnell work on cultural resource investigations?
Yes.
And are these 2 consultants that you would find to be reputable and knowledgeable in the fields that they were doing work on for the project?
Bear Creek, yes. Burns and McDonald, no.
Does the Office of the State Archaeologist compete with Bear Creek and Burns McDonnell for cultural resource management services?
Yes.
And indeed, your office will consult on projects both inside the state and in other states, right?
Rarely out of state, but we have, yes.
Let's turn to the Dakota Access Pipeline project particularly. When did your office first become aware of the project?
I would guess sometime in mid-2014, I think.
If I said around June, would that sound right?
Yes, probably around June, yes.
About that time, did your office receive from HRA Gray and Pape a KMZ and shapefiles for a project centerline to identify known archaeological sites?
I did not know that at the time, but I know now after the fact they must have because they accessed our site file through that request.
And HRA Gray and Pape is another cultural resource management
Yes.
company, right? Do you compete with this firm as well?
I'm not aware that they've done much work in Iowa, so very indirectly.
The KMZ or shapefiles that were submitted had a center line for a generic project and didn't state that it was the Dakota Access Pipeline, right?
I don't know.
Do you know if that material was provided to your office confidentially?
I don't know.
Does your office often receive confidential filings that don't identify a specific project or project proponent?
They're not typically marked confidential, but they come in that sort of generic form that you suggest, where there's not much identification to it.
I'd like to put up MH2, Monica Howard 2. Mr. Doershuk, I assume that you have seen this email before?
Yes. Mhm.
When did you first see it?
When it was posted as an exhibit, Mr. Taylor called it to my attention.
What did Mr. Taylor tell you about it?
He said I might want to take a look at it.
Did you say anything in response?
I probably said I will.
Did you have any follow-up conversation with Mr. Taylor about this email?
I don't believe so.
Is Melody Pope a research director in your office?
She is the former research director. She now works in Indiana.
When did she depart your office?
She left in October, late October.
Did she used to report to you through Steve Lensick?
Correct.
Were you aware that Ms. Pope was soliciting Dakota Access for RFPs?
I think she mentioned at the time that she had heard about this project and was making contact to see if there was a possibility of entering a relationship.
Did she have those conversations with you before the time of this email, which is June 10th of 14?
I couldn't tell you if it was before or after.
Do you recall any conversations about this email in more specificity, either before or after?
I think I probably said to her that that's great, glad that she'd learned about it, and good luck.
Because finding these kinds of projects that bring revenue to your office are important and valuable, right?
Oh, absolutely, yeah.
Are you aware of when the Dakota Access project became public?
No.
Thank you. Mr. Doershuk, I've asked for assistance in handing out exhibit number 9. I will note that the date on this document is June 25th of 14. Would you agree that's a couple of weeks after Ms. Pope's email to Mr. Daniels at Dakota Access?
Yes.
And do you have any reason to dispute that this was the public announcement of the project?
Certainly not.
Do you have any idea how your employee obtained information about this project before it was public, such that she could make a solicitation to Mr. Daniels?
I could speculate, but I don't have any specific information.
If in fact Ms. Pope obtained this information from the materials that have been supplied to your office, would that have been appropriate?
I'll object, Your Honor. There's nothing in the record to indicate Ms. Pope got this document.
I asked if the office had received a center line, which she did in June, and I'm asking a hypothetical if she'd gotten that information from that filing, whether it would have been appropriate.
And the witness stated that he had no knowledge of that.
Yes, he did, and then I asked a hypothetical of whether, if she had used information that had been provided to the office for consultation to gather the name of a project proponent, would that be proper?
But a hypothetical is inappropriate here when they're referring to a definite document.
Ms. Agramonte, I would ask you to restate the question in a manner that doesn't indicate any individual or person as a hypothetical.
I can do that, Your Honor. Thank you. Is your office the portion that does the research services for third parties, which represents 80% of your operating budget?
Do my activities?
Let me start over, I'm
Yeah,
sorry.
yeah.
Is it appropriate for persons in your office to use data provided for cultural service reviews by a third party for purposes of soliciting business?
I think so.
What makes you think so?
The conversations, the role of the research director in the office is specifically set up to be isolated from most of my day-to-day activities, and they're charged with bringing in funding sources that allow us to do archaeological research in Iowa. So they use whatever information they have access to identify potential clients, make contact, discuss services, potentially enter into a relationship.
Help me understand this. You are the state archaeologist, and you
Correct.
do research, and you have control over ancient remains, right?
Correct.
And a project proponent who wants to build something in the state is going to come to you to access your database and to get up information from you about cultural resources in the state, right?
Right. We maintain what's called the Iowa Site File, which is the official record of known archaeological site locations in the state.
How do you both work for third parties and have third parties come to you for this information and, as you say, required consultation?
Well, historically, there was a time when the only archaeologists in the state worked at the Office of the State Archaeologist. There were no other sources available for those needing these kinds of consulting services, and that's where the relationship with the DOT in particular grew out of. But through time, we consistently have folks who are developing projects not only ask for access to the site file, but also usually in the same communication ask for assistance in achieving the compliance process. So
All right.
more often than not, it comes hand in hand.
Okay, so
But there's no
sorry.
requirement that our services be used. An applicant can use any consultant they wish.
All right, so let me break that down. So Company X has a project. They want access to your site files. That's a service that the state archaeologist provides, right?
Correct.
And that's on the archaeologist side, not the research side.
Correct.
So I, as a project proponent, I exhaust the work that you can do for free by accessing your sites. Isn't that right? If I want anything else, I got to pay for it.
Well, no, there's a unless you come to the office and actually use the records that we have in the office, if web access is desired, there is a fee for web access to help us provide that service.
All right, so
or
I get. Go
a
ahead.
site search can be done by my staff if someone doesn't want to either access the web information or come and do the research themselves.
All right, so the state makes this information available. If I come on site, I can pay
Right.
for it to get it remotely.
Yes.
And if I want help with my cultural resources management, I got to pay you by the hour.
Correct.
What else does the state archaeologist do for project proponents that aren't paying by the hour for your consulting services?
What else? We have a education and outreach program that we provide lots of public information around the state. We do research projects that are funded by grants, that are funded by gifts. We are the state archaeological repository.
Let me,
Not sure what you're asking.
yeah, I think that in your testimony, both in your original testimony and then your supplemental, you're raising complaints that Dakota Access didn't consult with you, right?
Yes.
Okay. So what consulting, other than the consulting they would have to pay you for, did they not do?
Oh, well, that goes to my comment on page 1, I think it is. Yeah, comment number 1 on page 1 of the Exhibit 33, where I say that a project of this size, of the Dakota Access Pipeline, typically the consulting archaeologist that a firm like Dakota Access would hire would actually talk to me as state archaeologist, particularly when it's a company like Burns & McDonald who is not familiar with Iowa archaeology the way, say, Bear Creek is, about, as I say here, appropriate field sampling strategies, the documentation required, how to get through the process. And that I do for free. That's part of what I do. So any consultant can call me up and I'll talk as long as they want to talk about the details of how to do it right.
Okay. Nothing in your statute says a project proponent has to do that, right?
No,
We've already covered that.
Not has to do that, but it's
thank
best
you.
practice. Yes,
Doesn't have to. Statutory guidelines say you don't have to.
correct.
Thank you. Did you ever contact Dakota Access about this project?
No, that's not my responsibility.
So you had concerns that they weren't consulting with you, and your way to address that was to provide comments in this docket?
Yeah.
Following up on the exhibit MH2, Dakota Access ultimately didn't hire your office, right?
No.
Do you have any estimate of how much money the office may have received if it had gotten the work?
It depends on what the scope of the undertaking would have been. If it was just the areas that were examined for the Corps of Engineer jurisdiction areas, it would have been pretty small scale. If it was a 300-plus mile, 400 wide foot corridor from one end of the state to the other, it would have been substantial.
And what do you mean by substantial?
$1 million.
In your opinion, is the OSA the only cultural resource management firm qualified to perform surveys and analysis in the state of Iowa?
No.
Let's turn to your May 22nd, 2015 letter to the IUB that's attached to your direct testimony. I believe it's Exhibit 2. This is your first communication with the IUB, right? I'll give it a moment.
This is the May.
The May 22nd, 2015.
Yes.
At the time of this letter, as I understand your earlier testimony, you had not yet been approached by Mr. Taylor, right?
Correct.
Have you ever consulted for the Sierra Club?
No.
In your letter here, you expressed some concerns about 3 archaeological sites by name. Is that right?
Looks
Yeah,
like we have
second paragraph.
Meskwaki Camps, a fur trading post, and the Mahaska County Mammoth Find Spot.
I'm going to excuse my pronunciation, but let me walk through these one by one.
Sure.
So the Meskwaki camps, you stated they were historically significant but currently unknown locations, right?
Correct.
Isn't it true that there are no recorded sites within the Dakota Access 400-foot survey corridor in Story County?
I don't know that.
Do you know that the DAPL archaeologists identified 2 sites in the project area about 5 miles from these camps as part of its lit review?
No, those documents haven't been provided to my office for review.
Your testimony is that Dakota Access didn't provide you with any trinomials of these sites or others?
Now, that's not the same as giving a report. The site forms are submitted electronically. They go into the system. We're not aware of what project they're associated with when they come in.
Okay.
So there's no way for me to know what sites are associated or with this project or not.
So you actually are not aware of all the information that Dakota Access may have provided to your office regarding its survey of the route?
Correct. And that's the key to my comments, is that there has not been communication and consultation.
You don't have any guidance documents that the office has published that tells project proponents to come consult with you either, do you?
The Association for Iowa Archaeologists, which is the professional organization in the state, has published in 1999 guidelines for archaeological investigations in Iowa, which both my office and the State Historic Preservation Office endorse as standard practice.
Let's talk about those guidelines. You referenced the guidelines on page 10 of your testimony, right?
Of the October?
Yeah, the direct testimony.
Yes.
Isn't it true that that's not regulatory in any manner and is not intended to imply any type of mandate? Isn't that what the document says?
They are guidelines, best practices, standards, but they do not have regulatory authority.
Okay. And don't the guidelines also recognize that it's the responsibility and prerogative of the project archaeologist or agency to determine, implement, and document appropriate investigative findings?
You said two different things there, the project archaeologist or agency?
Yeah, I'll represent to you that I'm reading from the document, and I can have it pulled up if we need to. It's that the guidelines leave many aspects of field procedures to the discretion of archaeological researchers or federal and state agencies, and acknowledge the fact that it is the responsibility and prerogative of the project archaeologist or agency to determine, implement, and document appropriate investigative methods. Would you agree with that?
Yes.
Who has regulatory authority over cultural resources in the state of Iowa, other than ancient remains?
There is no state-level code to that effect.
All right, let's go back to my archaeological sites. The second site you name is the 1821 fur trading post, Blondo's trading post in Des Moines County. Isn't it true that that site has never been definitively located?
I believe so. That's why it says possibly, I think there.
And isn't it true that some accounts suggest that that post may be by the Raccoon River in the confluence with the Des Moines River, about 23 miles from the Dapple route?
I don't know the details of that.
Let's go to the last one, the Mahaska County Mammoth Find. Isn't it true that the Dakota Access route is more than 1,000 feet away from that?
I, again, was never provided official maps. We created this estimate back in May, going on to what was available on the web, which was a very rough estimate of where the pipeline was. So again, given the lack of information provided to the office, I had no way of being that accurate about it.
And you didn't seek out any information either in the IUB docket or from Dakota Access before you made these statements in your letter?
No, the information that we were able to access seemed to be reasonably correct, given that at that time there seemed to be some wiggle room, let's say, in terms of where things might end up. So it was, the point of this letter was to indicate that we were interested in consultating on this project and that we felt we had information that would be useful, that we were looking for some level of investigation by Dakota Access to make a good faith effort towards the guidelines, and that's really what I was calling out for.
All right, I'm a bit confused. We know that Dakota Access provided your office with the shapefiles, right? You guys got a centerline route back in June of 2014.
Again, we have this, that you said came in confidentially. Like I said, I didn't know that we had that information for this project. I was working from publicly available information.
Okay, are you done?
Yeah.
Okay. How did you find out about this project, Mr. Doershuk?
I think that probably the conversation with Melody Pope was the first tip-off. The other thing that I know that I noticed was that several cultural resource management firms were advertising on a web-based resource called Shovel Bums, which is where archaeological technicians look for work around the country. They were advertising for survey crews for Iowa projects, and these were out-of-state companies. Christopher Goodwin and Associates, you mentioned Graham Pape, Commonwealth, Cultural Resource Analysts out of Kentucky. Several firms were advertising for what looked like largish crews for projects unspecified. And I called up at least one of those offices just to inquire what was going on, and was told that there was a large-scale energy-related project that they couldn't identify. So I put 2 and 2 together and assumed it was probably this one.
What was the other part of your 2? You talked to people who couldn't identify a project, so you then assumed it was
No,
the project.
at the same time, there was this public information that there was a large-scale project going on.
And that didn't prompt you to call Dakota Access?
No, that's not my role. It's not my job to chase these people down. They're supposed to access the information that my office has
And they did.
consult.
And they
And-
did
and
access the office
They accessed the
information.
Iowa site file, but they did not consult with the office and the expertise the office has.
And again, there is no statutory requirement to
Nope.
do so.
Just best practice, save them a lot of hassle if they'd done so.
And there's nothing in your, I want to make sure I get the name right, in your guidelines for archaeological investigations in Iowa that requires consultation with you either, right?
That's correct.
You reviewed Ms. Howard's reply testimony, right?
Yes.
And I believe, if I'm recalling her testimony correctly, she states that the Dakota Access provided trinomials for 46 sites and 25 isolated discoveries. And I just want to clarify you wouldn't be able to comment on that because you don't know
Right.
that
Again,
came in?
that information comes in generically, in as much as it's just a form on that particular site. It doesn't identify who filed it. It could have come from one of a dozen people, perhaps within the Burns and McDonnell organization, or one of their subs. So there's no way to connect
Right.
that. It doesn't say this is for the DAPL pipeline project. Doesn't come in that way.
You have no basis to dispute Ms. Howard's testimony that information was provided, right?
I have no basis for being able to agree that that information was provided or done either.
That's fine. I just want to make sure that you don't have any grounds to say it wasn't provided.
Oh, no. I wish I had some grounds.
All right, let's go to your, what I guess you've called information that's come to your attention since your original testimony, Exhibit 33.
Oh, yeah, 33. Uh-huh.
You have the first statement, which we've already gone over. And then you have a concern about the unanticipated discoveries plan. That, for the record, so folks can follow, is MH7. I think the 2 concerns about the unanticipated discovery plan really relates to the age of remains that may be encountered and which agencies ought to be contacted. Is that right?
Correct.
And wouldn't you agree that that plan could be updated?
Oh, absolutely. I hope it is.
All right, and if it were updated to clarify that your office is supposed to be contacted if the remains are over 150, and that the Department of Public Health was supposed to be contacted for other remains, would that address those concerns?
It would.
And I think you also wanted your office to be listed in that plan. That would also
Well,
be something?
It would simplify contact for those involved if the correct contact information was provided as they went to the trouble, as I say, of identifying who the sheriffs were in the various counties who are also have to be contacted. So my office should be listed there. Yeah, that would make sense.
All right, so that would fix the concerns you have in the unanticipated discoveries plan, right?
Yes.
Paragraph 3, you talk about the U.S. Army Corps National Historic Preservation Act, Section 106 review, right?
Yes.
And the Army Corps is responsible for that review, correct?
Right.
And the U.S. Army Corps would be responsible for identifying the state agencies with which it should consult, right?
Correct. And I am listed as an interested party with them.
You
for
asked
this
to be a
purpose.
consulting party, right?
Correct.
You don't claim to have knowledge of all communications between the U.S. Army Corps and Dakota Access, do you?
Correct.
That would be no, you don't.
Or no, I don't.
Thank you.
Yes.
And you don't have knowledge of all the communications between the state SHPO and Dakota Access, right?
No, I don't.
If the Office of State Archaeologist had been hired, would you still be against the project?
I'd like to clarify that point. As I said at the beginning, I'm not here to say that the permit should not be issued. I'm not against the project. I am for the correct kind of documentation to be provided to allow the SHPO office and my office to assess and concur that sufficient archaeological investigations have been done to the guidelines of the Association for Iowa Archaeologists and to some of the other authorities that DAPL has reported to the board that they're trying to follow.
Yeah, the
So I'd
SHPO
like to see this information.
Yeah, the SHPO can make its own assessment of whether it has the appropriate information to consult with the, fulfill its consulting role with the U.S. Army Corps. Wouldn't you agree?
Oh, I would think so.
Okay, so you can't, and we went over it earlier, you can't speak for the SHPO.
No.
All right, so your only complaint, as I understand it, is you haven't gotten information that you would have liked, but which is not required by statute, and that's why you're providing these comments in this docket.
Yes, for the
Thank you.
non-federal portions of the project.
I have no further questions.
Mr. Pauly,
No questions.
Ms. Jacobs?
Thank you. Good afternoon, Mr. Doershuk. It's up
Oh, there we
behind
are.
you now. I know it
Right.
always confuses the witnesses. They hear these voices and wonder where they are. I'm going to be chatting with you a little bit about the roles of state agencies working with your organization. So I'm trying to get a little clarity around that.
Sure.
I don't think you've probably heard our chair talk several times about trying to figure out all of the requirements of the various governmental entities, whether it's a permit, authorization, verification, whatever it is. And you indicated that both in your direct testimony and just in the cross here today, that you don't require a permit.
Right.
But you require a plan before this kind of project would go forward, or you would like a plan?
Are you thinking about the unanticipated findings aspect?
Probably that, or you talked about in your direct testimony, actually on page 10, lines 16 through 18, you say you expect the Iowa Utilities Board to require adequate archaeological survey and development of unanticipated discovery planning.
Right.
So you
the-
expect, is that a mandated step, the survey and the plan?
That harks back to the role definition that we talked about under 263B, where it's my job to promote and preserve Iowa's past. So my expectation in that role is that, yes, we would very much like to see adequate survey done to protect these non-renewable resources and the documentation of what was done so that it could be assessed as whether it was adequate or not to the task.
But as we look at requirements of other agencies, whether it's Department of Natural Resources or whomever, they have requiring permits. Do you
Right.
require this plan
No,
before?
we don't have that kind of authorization, unfortunately, no.
Okay,
Now the unanticipated findings plan does speak to what happens if human remains are found, so that is covered under state code.
Absolutely, and I understand
right,
that. Then I go to your, I will go to your Exhibit 2, which is the letter that you sent as comments to the
Yes.
IUB on May 22nd.
Okay.
And I go to the end of the third paragraph where you state, if this were an Iowa DOT or DNR project, the entire area of potential effect would be included in requirements for archaeological compliance, and DAPL should be subject to the same level of scrutiny to which we hold Iowa agencies. So you're requiring a private entity at the same thing you're requiring of the DOT and DNR? Is that what you're?
Well, that would be under projects that would be federal undertakings per the National Historic Preservation Act. So the Department of Transportation and the DNR, when they get federal permits or funding, adhere to that standard. And I'm recommending to the utility board that they invoke a similar level of compliance under their authority for the Dakota Access Pipeline.
And this letter was filed as comments on this project. What other communication did you have with anyone at the Iowa Utilities Board?
Oh, none.
So something that was filed as comments, that we have thousands and thousands of comments on this.
I
This was
realize that
read.
now. I'm impressed by how many.
This was read, and so I guess that takes me back to Chapter 263B, where under duties, it says that you shall coordinate activities with cooperation with the various other state agencies concerned with archaeological salvage. It feels like a step maybe was missed here. Is that, I'm a little confused as to where that potential coordination could have been, so we might understand if there was something that was needed by another state agency or desired by another state agency. Help me understand why maybe there wasn't additional outreach by either you or someone in your office to our staff.
I think typically the State Historic Preservation Office has served as a communicating agency with your board for projects of this type. And oftentimes they keep me in the loop, and I may have communication with them, but that they've been the primary communicator. Now, in this case, it was complicated by the fact that the review archaeologist at the State Historic Preservation Office, who would have been assigned this particular project, is an affected landowner. So he was recused from that role, which left them with a gap. The Deputy State Historic Preservation Officer, Steve King, is an architect by training, not an archaeologist, so he felt a little out of his league in terms of dealing with this. He couldn't rely on his staff member. So he had started communicating with me about it, strategizing, trying to determine what was to be done. But I think that's probably where the breakdown was that the State Historic Preservation Office didn't have its usual personnel in place to communicate with the board,
And
potentially.
So typically it would be somebody from SHPO that we would hear from. And
probably
in
so,
this case, you felt that somehow that gap needed to be
Yeah.
closed, and so used the comment approach, which hindsight's always.
I have to admit, I'd never used your web-based system before. I didn't know what to call the thing.
And it probably would have been easy if you just maybe picked up the phone and talked to one of our safety
Possibly,
and engineering staff.
But I wanted to get something in writing too, so.
Well, and that's understandable. So at this point, it appears that you're expecting the IUB to do something, but it's not a requirement for the project.
I cannot, I have no legal jurisdiction to require anything other than what's common, best practice, what other agencies would do for similar kinds of projects in terms of land disturbance.
Right. Okay, that's very helpful. Thank you. That's all my questioning.
Mr. Wagner.
Thank you, Madam Chair. Mr. Doershuk, have you been contacted by any state agency other than SHPO about this project?
I have not. I know SHPO has had discussions with NRCS and with the USDA,
Okay, so
but I have not been.
the DNR or the DOT, neither
No,
one
no.
had, okay. And if your duties say that you shall, pretty specific, coordinate all such activities through cooperation, did you feel that did not give you the authority to contact Dakota Access if you felt there was something missing?
Well, again, the common practice is that the applicant, those who are doing projects, seek out the agencies
Okay.
and make that contact. So, I mean, I could have gone online, I suppose, or tried to figure out from a newspaper article who to contact, but
All right. And then you said, it was early on in testimony, when was the last time you had contact with Mr. Taylor from the Sierra Club?
face-to-face or email or?
Well, any contact?
Oh, well, I guess we've been emailing back and forth what day to come, but I emailed him my November 30th letter on that day, so that would
Okay.
have been the last substantive.
Okay, so you emailed that to him.
Yeah.
And you didn't have any contact with him prior to that?
Well, yeah, he had just about what day to come.
But I mean, before you filed your...
Before the October 12th,
No, the November, your latest...
the November 30th.
Yeah, the November 30th.
Yeah, no, not in between.
Okay, so you reviewed, did you watch or see Monica Howard's
Oh, no,
testimony
I
in
haven't
this,
had, I
in this
have,
hearing?
there's 28,000 archaeological sites in Iowa I have to keep track of, so
Okay.
there's many other things I'm doing.
Okay, so once you wrote that letter, then you sent it to Mr. Taylor, and then he
Right.
then filed it.
Yeah, and then the course of setting up the date for me to come today, he indicated that if I had additional information that I could convey it. He didn't indicate whether I should give it to him ahead of time or not. I chose to write it out to try
Oh,
to make it brief.
So he did say,
And-
please provide
But he just said,
anything else.
if you have anything else, I'd have a chance to present
Okay,
it.
so you wrote the November 30th letter in response to his asking you to do that.
Well, he didn't ask me to write it out. I chose to do that.
Correct,
He
but
just said,
he said if you have anything to add.
yeah, right.
Okay,
Yeah,
I think,
yeah.
okay,
Because I was asking, well, I didn't understand what would go on here, and
Sure.
if I'd have a chance to
Yep.
say these things or not. So
yeah. And so nobody from the OCA, from the Officer of Consumers Advocate's
Oh, no,
office
no.
contacted you
No.
along the way to testify or anything? Okay. I think that's all my questions. Thank you very much.
Okay.
Good afternoon, Mr. Doershuk. I wanted you to explain to me how the process is supposed to work. So we've been using this little timeline from construction to the end. And what I've been hearing is that information that your agency would provide would be prior to this starting, but is there also what occurs when?
Right,
Can you
right.
just tell me so that I understand in my mind how it works?
Yeah. There's if we use the National Historic Preservation Act as a model, basically, for how cultural resource management activities occur across the country, federal agencies require their applicants to provide them with documentation that no significant historic properties, is the term that's used, will be affected by the undertaking. And historic properties can include things like buildings, built architecture, that kind of thing, but also archaeological sites, including those that are buried under the ground surface, don't have any surface visibility. So a typical first step for an applicant like Dakota Access would be to hire an archaeological consultant, which they did, Burns and McDonnell, and some others, I guess, have been involved. And one of the steps that those folks would take would be to access the Iowa site file. Now, a company in state like Bear Creek Archaeology has a license. They can do that 24/7. We don't even know in my office that they're doing that. But these out-of-state firms that didn't hold a license had to go through the process of either getting a license or submitting the corridor information so that my site record manager could respond. And I don't, again, know the details of how that was resolved, but that initial contact is to learn about what's known already. So the Iowa site file, which has 28,465 sites or so at the moment, is a record of all known archaeological site locations in the state. And it's a great first stop place to check to see whether a project is going to impact something that's already known. The vast majority of the Iowa landscape has not been professionally archaeologically surveyed, however. More often than not, particularly with a large land disturbing project of this scale, field surveys are necessary to ascertain whether or not there's anything out there that might be impacted.
Okay, before you go on, just in my mind, I have to get it. So this step would occur after the informational meeting, but prior to the final.
I'm not sure where the informational meeting starts and stops.
How far in advance of submitting a plan or so I'll withdraw that.
Okay.
Keep going from this
So,
part then.
so once the known data has been accessed, then it's easier to determine where one has to look in the field to generate the new information. And based on Monica Howard's rebuttal testimony, she listed off that they had done so many miles of survey and had found so many archaeological sites, they were all to be avoided. That's great. That's exactly what I want to see happen, is avoidance where possible of these resources. They do that by shifting the line a few hundred feet north or south along their alignment. But a critical part of this process is not just someone saying they did these things, but them providing proof, documentation. And the guidelines for archaeological investigations in Iowa that the professional society, which Bear Creek Archaeology belongs to, my staff belongs to, all the other private consultants in the state belong to, they have created these best practices as a basis then for the State Historic Preservation Office to use in their review, particularly of the National Historic Preservation Act federal undertakings, but in general, all projects. This is the standard that we say as professionals in the state that we want to see in terms of documentation, and that documentation has not been provided. Now, for the 29 areas that are under the Corps' jurisdiction, what they call the PCNs, I think is the acronym, reports have been submitted. And since I requested interested party status with the Corps for those 29 locations, I've been provided those reports and I've reviewed those, and they don't get anywhere close to providing the kind of documentation that's typical under the guidelines. So I have extended comments on those. If the board would like to see those, I can submit those.
Okay, before we get to that, when we start this process, however, where is involvement for those, I believe they're called unanticipated?
Okay, yeah.
When does that occur in this map?
So everything I've described up to this point in time, we want to see done, documented, and confirmed at step one there, before there's any ground disturbing activity. The unanticipated finds and the plans for those, which are required for the National Historic Preservation Act, so they put that together to address specifically the Corps' requirements for their permit. That is to handle what happens under when block 3 starts, when dirt starts getting moved, and through 4 and 5 and 6, when all that dirt's getting pushed around and moved, all that's the time when something unanticipated might come up.
Okay.
Because archaeological sampling uses a relatively small hole, as a sampling. It's not 100% exposure like this pipeline corridor will create.
And who would you expect to report that information?
That's accurately in the plan. It's the construction, what do they call them? The construction
Inspector?
inspectors.
That's hired by the county supervisors?
I don't know about that part of it, but
Question for Mr. Mahmood, I bet.
possibly. But yes, on some National Historic Preservation Act projects, the federal agency will require an applicant to have a trained archaeologist monitor during construction, but I'm not aware that that requirement has been put forth by the Corps on this one.
To your knowledge, does the Iowa Utilities Board have the statutory authority to require an archaeological survey and development of an unanticipated discovery plan?
I don't see why not.
And what is the difference between an unanticipated discovery plan and an unanticipated findings plan?
I don't think there is one.
So it's the same thing?
I think so.
You've stated on page 10 of your testimony that in an answer to a question on a survey of the entire corridor, an approach would be typical if this were a natural gas pipeline.
Oh, there we go.
Can you tell me if it was a natural gas pipeline, what is required in that case?
That would then be under the authority of FERC, the Federal Energy Regulatory Commission, which as a federal agency would invoke the entire pipeline corridor, staging areas, access roads, all these as part of the area of potential effect for the project. It would be a federal undertaking under the National Historic Preservation Act. Why the history of things is that oil pipelines are not regulated the same way at the federal level, I don't know. I would imagine at the time of the passage of the National Historic Preservation Act in 1966, oil maybe had a stronger lobby than gas. I don't know.
Thank you. Mr. Taylor?
Thank you. Dr. Doershuk, what, in your experience as a state archaeologist, is the usual custom or your usual experience with the developers of projects like a pipeline or any private development with your office concerning archaeological investigation?
Objection asked and answered. He's covered this a couple of times in cross with me and with the board.
I don't think he really did. I think the effort of the cross was to show that he had no regulatory authority. What I'm asking is, what is his usual experience with projects like this and the consultation with his office?
I also don't think he's identified a usual pipeline case either, but I believe he had an opportunity to describe what he would expect.
Mr. Taylor, please rephrase your question.
What is the customary experience or a procedure that you have experienced as a state archaeologist in terms of consultation with your office and the private developers who are engaging in a construction project in terms of archaeological investigations?
Same objection.
Mr. Taylor, are you wishing to ask him whether or not there's any additional information other than that which he's already testified?
I'll withdraw the question.
Thank you.
You mentioned the State Historic Preservation Office in response, I think, to a question from one of the board members. What is the relationship between your office and the State Historic Preservation Office?
I guess it would be accurate to say we're sister state agencies insofar as part of my duties are code mandated, and We support one another's activities. I provide the Iowa site file information to them. They provide information on completed survey areas for us to complete that database.
Thank you. That's all the questions I have.
Thank you, Mr. Taylor. Mr. Doershuk, you may step down.
Madam Chair, Mr. Magrum is here. Can he go next?
Yes. Mr. Murray, do you need a break?
No.
Mr. Sandgren, do you wish to admit SEHNCR2?
Chair, I also have one that I realized I did not ask.
SEHN2 is Raffensperger, Perger
testimony.
objection, I believe.
Yeah. That, I understood that that had already been admitted.
Apparently, according to Mr. Wright, it is not.
I know that we've had a standing objection to objections, but I know where the ruling is going to come.
It's admitted. And what exhibit did I not admit of yours?
I did not move nor have admitted Exhibit 9, which was a cross exhibit with Ms. Raffensperger.
Is there any objection to?
No, sorry. It was with Dr. Doershuk, sorry.
Dakota Access cross exhibits 2 through 9 are admitted.
I think that takes care of it.
Not want a break. You may call your next witness, Mr. Taylor.
Thank you. Call Jonas Magrum.
Good afternoon, Mr. Magrum. Please raise your right arm. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
You may be seated.
Thank you.
Mr. Taylor?
State your name, please.
Jonas Magrum.
Have you previously submitted pre-filed written testimony and exhibits in this case that have been admitted into the record?
I have.
Do you have any additions or corrections to that pre-filed testimony?
Yes. In response to Mr. Fry's reply testimony disputing my claim that Bakken crude is more volatile and corrosive than
Objection.
conventional
Objection.
crude.
Hold on a minute. Hold on. I don't want your objection yet either. I need to find his testimony. I know I have it. I have them all out.
I have an extra copy if you need it.
I have it. All right. Please state your objection.
And Your Honor, this is a problem with the additional information that Mr. Taylor solicited from Dr. Doershuk as well. Corrections are when there's a typo, when there's a number wrong, when there is an updated fact over passage of time. What Mr. Magrum is describing and what Mr. Taylor is seeking to solicit is, frankly, surrebuttal testimony. That is not an appropriate use of testimony corrections.
Mr. Taylor?
What we intend to add to Mr. Magrum's testimony are Exhibits 6, 8, 9, and 10, which were previously filed, and that I addressed with Mr. Fry, and they were not admitted. But I think Mr. Magrum is entitled to refer to these exhibits as clarifications or additions to his testimony to support the statements that he made in his testimony. He's not changing his testimony or adding any additional information, but simply citing the references that support his testimony.
They might wait. He said they might not.
Mr. Taylor, can you repeat the exhibit numbers?
Yes. These are Sierra Club Exhibit 6.
Okay, stop right there. Hearing Exhibit 6, I have was admitted on 11/23.
Thank you. The next one is 8.
8 has not been admitted. Next,
9
not.
and
Next.
10.
So, what you're attempting to do is to admit your hearing exhibits 8, 9, and 10. Is that what you're attempting to do?
Yeah.
Get that. So for hearing exhibit 8,
Excuse me.
it's fine. It's one of those moments in the day. For hearing exhibit 8, have you provided Mr. Dublinsky with a copy?
It was pre-filed electronically before this hearing even started.
I have a copy here.
And are you objecting to hearing exhibit 8?
I'm objecting to 8, 9, and 10, and all for the same reason.
Okay.
First of all, I think when you start a question with, in response to Mr. Fry, that's going to be pretty hard to overcome. It's pretty clear that he's trying to get cross that he couldn't get through Fry through supplemental direct, but there are two ways these could have come in. Mr. Megram filed testimony. Mr. Taylor's had numerous witnesses file testimony. If they wanted to affirmatively build a case through exhibits, they could have attached those and utilized them in direct testimony. Second, he could have used them as cross exhibits with Mr. Fry. He tried and was unable to lay a foundation, and essentially is seeking a mulligan on the failure to lay the foundation, which is also inappropriate. So we object that there is no way through this witness to try and get exhibits in that were intended to be used with Mr. Fry. That's just not an appropriate use of this witness's opportunity on the stand.
Mr. Taylor?
I think that if this witness relied on these documents, among others, for his testimony, that it's appropriate to supplement or add to or clarify his testimony with these exhibits, because it did not change his testimony at all. He's not correcting his testimony. He's simply adding to it by presenting the information on which he based his testimony.
And Mr. Taylor, I understand what you're attempting to do, but I have been attempting also to try and make sure that we follow the standards that we set out, and I am sustaining the objection on exhibits 8, 9, and 10.
With that, we tender the witness for cross-examination.
Mr. Lozier,
We have no questions.
Mr. Piazza, Mr. Dublinsky,
No questions, Your Honor.
Mr. Pauly,
No questions.
Ms. Jacobs,
I have no questions.
Mr. Wagner. And I have no questions. Thank you, Mr. Magrum.
Can we take a break now?
Yes, we'll break for 10 minutes. Mr. Prey, thank you for calling your first witness. Do they have their mic on? You may approach. Mr. Prey, please call your first witness.
I call Ken Anderson to the stand.
Mr. Anderson, please raise your right arm. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
You may be seated. Mr. Prey?
Can you please state and spell your name for the record?
My legal name is Kenneth Anderson, KENNETHANDERSON.
The record, are you submitting this testimony on behalf of another entity?
Yes, our family farm corporation called Prendergast Enterprise. Do I need to spell that?
Sure.
Okay, it's PRENDERGAST, Enterprise, Inc.
And for the benefit of the Technology Bureau, if it's necessary, can you describe what part of Calhoun County this farm is in?
Section 11, Township 87, North Range 31 West.
Where is that in Calhoun County? North, south, east,
it's
west?
south of Summers, the city of Summers.
Are you the same person that previously pre-filed written testimony and, well, just testimony?
Yes.
All right. And you have a copy in front of you?
Yes, I do.
Do you have any corrections or additions?
No.
I move the admission of the testimony and I guess just the testimony, and tender the witness.
For your information, Mr. Prey, all of the testimony has been admitted. If there's an exhibit or an objection, and as long as there's no objection, all testimony is admitted. You'll then have to move to admit exhibits or objections. And I also would like to point out, if you use the witness specific, the identifier for the property is listed on there for your convenience, and they can pull up the property map so that it's up for.
Yes. And that, I talked to your Technology Bureau, and they said they would like the additional help of what part of the county it's in.
Okay. Mr. Lozier,
No questions.
Mr. Piazza. Mr. Dublinsky.
Thank you. Mr. Anderson, are you an attorney by chance?
No.
I have no further questions.
No questions, Your Honor.
Ms. Jacobs.
No questions.
Mr. Wagner. Mr. Dublinsky, I'm going to ask you the question. We already know we're going to ask the questions. We want to know whether you would like the board to ask the questions. They are the same ones that we're going to ask all of the landowners, or would you want their counsel, if they're represented by an attorney, to ask the questions, and we'll give them the sheet?
Your Honor, let me just make a record, and I understand your position. Where there is a represented landowner, we would object to the process. And in this particular landowner, where they had an opportunity to file testimony about the sorts of questions you're going to ask, the reason I asked the only question I did, which is, are you by chance an attorney? This is a two-page testimony. The first page is essentially the legal description. The second page is almost entirely an argument why allegedly eminent domain here is unconstitutional. It is a strictly legal argument. There are no facts unique or relevant to the land, and we would object to the board, particularly on a represented party, essentially giving a second shot when there's just nothing in here except legal argument. I understand the board's position on this, and if I have to make a choice, I would say, Your Honor, proceed and do it the way you have with all the landowners. But for the record, particularly in this case, we do have an objection.
The objection is noted. Do you object to me asking the questions, Mr. Prey?
No, I do not.
Thank you. Please pull up the overall county map for Mr. Anderson's property. Mr. Anderson, if you can see the hand that's on the property, is this the property that?
No.
No.
No, ma'am.
Right there. There we go. Is
Good.
this the
Yes,
correct property?
That's the correct property. Yes, ma'am.
What is the use of the property?
Corn and soybean farmland.
Do you have any plans for different use of the property in the future?
No, ma'am.
Does the property have drainage tile or other installations?
Yes, according to the map that I received from Dakota Access and their survey, where they're going through, if you look up here in the, this is not me being rude because I can be rude. I am simply going to keep you to the question I'm asking. So is there drainage tile, yes or no? yes, ma'am.
Is there any other type of installations on the property?
Yes, ma'am. I don't mean to be rude either, but by their survey, there is a neighbor's well that is right in the easement area. And it's an active well. And my concern is if and when the oil leaks into that well, who's going to be responsible for it?
So there's a well on your property
my
that
property.
belongs to the other.
To the gentleman, I don't know his name because he's kind of weird, so I avoid him. I'm sorry. He's been trying to build his own house for 15 years and it hasn't gotten done yet. So,
Good relationship you have going on.
yes.
Okay. Yeah, you do understand this is being live streamed,
Yes,
correct?
I understand
Okay.
that.
Great.
And I don't think he has TV or internet, so I think I'm safe. And I can always fall back to that I was drunk.
Do you have any natural gas or other pipelines on your property?
On this particular piece, no.
And I'm going to ask you two questions that I would respectfully request that you keep limited to your property and your position on the same. Can you tell me exactly what you're looking for in terms of relief?
What do you mean by relief? I understand.
What are you presenting to this board? What do you want to tell us?
I don't feel that it's right for a private company to come in and basically through eminent domain steal my farm ground, even though they're going to be compensating us. It is still what happens to America where private ownership meant more than big money and big oil. I don't think it's right that our amendments, our constitutional rights are being eroded away every day. Our freedom of speech is going away. They attack freedom of religion. They attack the Second Amendment. They
Okay,
attack.
now you're going, yeah.
I'm sorry.
So back to the piece of property, you have a pipeline going across it. You've identified for us that there may or may not be a well belonging to another individual.
Yes.
That issue should be addressed.
Yes,
Is
ma'am.
there anything else related to the location of the pipeline?
Oh, yes, during the construction of the pipeline, the tile that's there is, we don't have any records of it because my grandfather passed away in '06 and he did everything by memory. My best estimate, it's at least a 24-inch tile. It could be plus or minus bigger or less. How are they going to pump away the water when we have our wet springs and they have their trench, or we get another wet August or whatever? How are they going to pump that water out of there? I mean, they can't legally block that tile and back flood all my neighbors.
Okay. Thank you very much. Mr. Prey.
What? I don't have any redirect.
You may step down.
Okay, thank you.
Mr. Prey, who is your next witness?
I will call Leonard Larson to the stand.
Hello, Mr. Larson. Do you swear to tell the truth, the whole truth, and nothing but the truth?
So me God.
You may be seated. Mr. Prey?
Please state and spell your name for the record, please.
Leonard Larson.
For the record, are you submitting this testimony on behalf of another person or persons?
Yes, I'm submitting this on behalf of my mother and my sister who own the property.
Can you identify them for the record?
Leona Larson and then Arlene Louise Bates.
And for the technology desk, can you identify for them roughly what part of Story County this farm lies in?
This is in the southeast corner of Story County, about a half mile south of the town of Cambridge.
And you're not a lawyer?
I'm not a lawyer. I'm a farmer.
What do you farm?
Corn, soybean. This farm here has been, I farmed it for 48 years, for 40 years, and it's primarily just corn, soybean. Has been the family since 1907.
Are you the same person that previously submitted written testimony in this matter?
Pardon me?
Are you the same person that previously signed and had me file testimony?
Correct.
Do you have any corrections or additions to your testimony?
About the only other addition I'd say is that across the road from our property to the east, a church has property.
Having no exhibits to move, I ask that this witness be tendered for cross-examination.
Mr. Lozier?
No questions.
Mr. Piazza? Mr. Dublinsky?
No questions?
Mr. Polly?
No questions.
Ms. Jacobs?
I have no questions.
Mr. Wagner? Mr. Larson, if you look at the map, is this your property that the technology desk has
Correct.
identified? And you stated that the use of the property is agricultural?
Correct. Corn, soybeans. The last, well, I've been farming it for 40 years. Been primary corn, soybeans.
Do you have any plans for different use of the property in the future?
Oh, just the property to the north. There's a creek that runs through it, and that property owner has been contacted a few different times for building houses. Across the road to our east, there's a housing development with about 4 or 5 different houses. And then, as I stated, across the road is where a church is purchased ground. And so that, yes, with those locations through there, there's a potential for development for this location. But with the pipeline coming through, it really creates hardships, headaches, and everything else.
Does the property have drainage tile or other installations upon it?
Yes, I've put in the last number of years, I've gone and put in a number of tiles in myself.
Can you tell the board exactly what you're looking for in terms of relief as it relates to your property?
Well, as I visited in front of you on the very first day of the public, on your back page of the handout that you had there, it states that the requirements that needs to be promoting public convenience and necessity. And as I stated on that day, for the last 11 months, I've been trying to watch every one of the letters that you guys received, and I have not been able to see necessity being filled on the whole business. I hear different comments about trying to get for some partial economic benefit for a few months, about like a firecracker type situation. But even watching the live stream, I haven't seen comments about for necessity. And so that I'm concerned about the following of the Constitution of a private company coming and taking my private rights and not being fulfilling for what the state law says that it has to be necessity has to be followed. Because President Obama hasn't asked for this, U.S. Congress hasn't asked for it, Governor, so we don't have a, and we haven't stood in line for.
Your relief that you're requesting would be to not have the pipeline, correct?
Not have the pipeline.
Okay. All right. Do you have any natural gas or other pipelines on your property?
Not on this property. On other properties, yes. We have natural gas transmission lines. Even the interstate system took our ground.
Thank you. Mr. Prey?
No redirect.
Mr. Prey, you may call your next witness.
I call David Lohman to the stand.
While we're waiting for the mic, Mr. Dublinsky, did you want to make sure that your objection applies to all the landowners?
All of the represented landowners, Your Honor. Yes,
Okay.
please.
Mr. Lohman? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
You may be seated. Mr. Prey?
Please state and spell your name for the record.
David Lohman, spelled Lowman.
For the record, are you also submitting this testimony on behalf of another entity or entities?
Yes, two entities. One would be my family farm corporation that I am the sole owner of, and then the other would be my family's limited partnership, which my corporation is the managing and general partner for.
Can you identify the names of those two entities?
The entities are Lohman Bros. Inc. and Walnut Creek Limited Partnership.
Are you a lawyer?
I'm not a lawyer.
All right. For the technology desk's benefit, have they identified the approximate location of your farms on this map that's shown?
Yes, yes,
Right.
there's on center page.
Are you the same person that previously submitted written testimony in this matter?
I have.
Do you have any corrections or additions to that testimony?
I do have additions. There is a concern that's come up. I kind of felt pressured in the amount of time that was that I seemed to find to get my objection in, and there is one issue that I feel is of significance that I do have, an additional objection.
Your Honor, I would object to the additional objection. I don't think there was any shortage of time. The time was the same for all of the witnesses in this case, and certainly the procedure in this state has actually been longer than it has been in the other states on the line. So I would object, as I would with any party or witness to essentially supplemental direct under the guise of corrections.
Mr. Prey?
I don't know what the nature of the addition is, so perhaps if the board could, I can tender the witness, and we can see if the additional concern is one of the things that would come up through your questions. I might also add, since I don't know what it is, I don't know what the basis for the objection was, or if I need to ask it on a special question.
Well, I think what I know is that the objection is that he's adding to his testimony. I think that he's made the statement, I'm going to ask him questions anyway where it's probably going to come up. So what I'm trying to figure out is if you want to make your general objection, but I'm going to ask him what the remedy he's seeking is.
Understood, Your Honor, and I believe with the last witness you agreed that I didn't. That it was a general objection, and as for the specific question, if it comes up, I know better than to object to the question of the chair.
And I might add, I do have a witness who has told me that something has happened after the deadline for filing testimony, and that the route was completely changed on the property. So I do know about that one. That is one I would be asking that witness to offer additional testimony. I do not know if this witness has a similar issue.
And we do want to know if there's a route change. That is important information for us to have. Mr. Lozier?
We have no questions.
Mr. Piazza? No. Mr. Dublinsky?
I will be taking this witness, Your Honor.
Ms. Agramonte?
I do apologize. Our continuing game of ping pong. We'll
No,
try to
it's
alert
fine.
you.
I just, as long as you know, I sometimes figure it out, but
Good afternoon.
Good afternoon.
I have a few questions for you and appreciate you coming to the hearing. Can you tell me who wrote your testimony?
Who wrote it?
Yes, sir.
I had a little advice from the attorney, but generally I wrote it.
You're a farmer in the state, isn't that right?
Yes, I am.
What crops do you grow?
Our farm has grown crops since before I was born, basically corn and soybeans, some pasture land.
Do you use petroleum products in your farming operations?
Yes.
And do you expect to use them in the future?
Yes, hopefully not long.
Would you say that at least under current farming techniques that petroleum products are necessary for you to be a farmer?
At the immediate present time, yes.
Are you aware that Iowa doesn't produce any crude oil?
Yes,
And it doesn't refine any oil either, right?
I'm aware of that.
All right, so you understand that the state is dependent on sources and refineries out of state.
At this time, yes.
Let's turn to page 2, line 7 of your testimony. You assert that any statements of benefits of the pipeline is a false statement. Did I accurately summarize your testimony?
Yes, I don't feel it's a benefit. I think it's an archaic industry that we need to move on from. We need to find alternate sources of energy. And I believe there are things superior to wind. I believe there are things superior to solar. And I believe those things are suppressed. And I am convinced of that. And that's why I made the statement I made.
Is it your position that there is no economic benefit to this project?
I see no benefit to consumers, and that is based off of testimony I've listened to on live stream. I see no benefits to Iowans for this project.
My question was a little narrower, and I want to make sure I understand your position. Are you testifying that you believe there are no economic benefits from the project? And I'm not talking about just consumers. It could be much broader than that.
To be frank with you, I think that you're basically ginning up a job excuse, and that's not relevant in the overall look and the overall scope that I think the board should look at. I think that's basically a ginned up excuse for your side of the argument.
Okay, so all the laborers and union representatives who've come and testified, you don't believe what they're saying?
I believe what they're saying, but I think there's an overarching argument that needs to be made that applies to them and all Iowans.
Do you dispute Dr. Lipsman's economic analysis that shows there'll be $1.1 billion of economic benefit in the state?
I have no awareness of that other than what I've heard.
Would you consider additional tax revenues to the state an economic benefit?
Depends on what's used for.
But it could be an economic benefit, you would agree?
Some people might view it that way. I wouldn't necessarily. You'd have to name what it would be used for me to say.
Right, so the mere fact that local governments would have additional funds is not in and of itself a benefit. Is that your testimony?
I can't say that it's definitely something that I would see as a benefit. It's how it's used, I guess, is my opinion.
All right, so unless you know how it's used, the mere addition of funds to the local county coffers for tax revenues is not sufficient for you to find that there's a benefit.
I'd like to think it's a benefit, but I don't know that it would be.
Let's look at page 3, line 21 of your testimony. All right, I'm going to start at line 20. This is where you were trying to compare, I believe, the current situation, and please correct me if that's not right, about where moneyed thugs can move in with support from corrupt local politicians and take property away. Mm-hmm. Were you trying to make an analogy to Iowa with that statement?
No, it's simply a statement that makes it plain that there can be corruption that ultimately erodes a very vital thing that's essential to a democracy, that's essential to a country that represents human sovereignty, that represents individual sovereignty, and it's a situation that I don't want to see our nation move into, because I feel it's a very dangerous step. It is an analogy, but it's something that I'm not comparing as a direct analogy. It's simply something that I see us moving closer and closer to every day.
Is that intended to apply to this process in any way?
I'd like to have the greatest faith in this process, but I've seen very disappointing things happen in the past. I've heard of other cases, and so that very much has eroded my faith to a degree.
All right, let's look at page 4. And here I want to talk about lines 15 through 17. You testify that there is no plan in place or decided upon that would fully restore land or landowner or replace the lost productivity to the state. What lost productivity were you referring to?
Lost productivity after a catastrophic spill is what I wrote.
Do you have any understanding of the resources available to Dakota Access to clean up and remediate any release?
I've heard some testimony. I'm sure I've not heard it all in regard to that. I know that it's a very complicated process. I know that after someone has been injured, there can be huge time delays before they're compensated or before they're made whole. And I don't see that. I see that the nature of this entire operation could drag those complications out for an extremely long time, and that there would be real harm done to somebody who was injured after a catastrophic spill.
Are you an expert in environmental remediation?
No, I'm not.
Do you have any experience with making a claim for a petroleum release?
I haven't.
I have no other questions.
Mr. Long,
No questions.
Ms. Jacobs,
I have no questions.
Mr. Wagner. Good afternoon.
Good afternoon.
I would appreciate if you would again verify that the 3 parcels that we're looking at that are on the screen, in the middle of the screen with the hand location, are the parcels for which you've testified.
They are.
Could you, for the information of the board, we would like to know where the forested area is on this map that you've described in your testimony.
It's the more northern parcel.
Would that be the correct location?
Yes, basically the hand is literally in the is in the timber ground, yes.
And then you've also stated that there's cropland. Could you show us how many acres is in?
It starts out timberland, then there's a little bit of cropland that would be crossed, and then it goes back into timberland, and then it goes into the Lohman Bros Inc. parcel, which is cropland, and then once it crosses the Kelly Blacktop, it goes diagonally across the large field, and would be all cropland there.
Is that entire second parcel all cropland?
The middle parcel is all cropland. Well, yeah, as far as what's being crossed is all cropland, yes.
And do you have any plans for a different use of the property in the future?
Yes, and that's the issue that I failed to put in the original objection.
Can you please describe to the board
The
what that use is?
parcel that contains the wood I consider to be a very prime possibility for development. Our family has already considered it. We've rejected it for a few years, but we very definitely consider it for the future. And my concern is this, is that if that pipeline is put in, it diminishes the value of the property radically. And the reason I say that is you literally have a situation where my understanding is that if all works well, you have a 5-mile long, 30-inch diameter tube pressurized at near scuba tank pressures that could explode explosively, that could rupture explosively. So ethically, how in the world can I sell those properties? Obviously, I can't sell them on the right of way itself. Obviously not. That would be not allowed. But even the property next to those properties, what do I say to somebody? I mean, it would be totally unethical and immoral for me to not explain to them that they are living next to something that could explode explosively, that's under 1,440 pounds of pressure, and I understand that they have the right to bypass Iowa law or any Iowa rules, and they could increase that pressure to 2,000. At that point, you're literally at scuba tank pressures. If you've ever seen something explode that's at scuba tank pressures, it's devastating. It's awesome. And then to add on addition to that, the fact that there's a fuel involved, or possibly even 2 fuels involved, you know, it's just not ethical to sell somebody that property next to that. It's obviously not on it, or even next to it. It's not ethical.
Does the property have any drainage tile or other installations?
We definitely have drainage tiles. I wouldn't be able to help much with that. Whatever the county would have would be all that I would have.
Do you have any natural gas or other pipelines on the properties?
Not that I know of.
And as I've stated before, I'm asking this question as it relates to your property, but can you summarize for the board your precise concerns with the proposed crossing?
The ones I just
Anything in,
stated.
okay,
The ones I just stated,
all right.
I generally don't want it at all. I think it's a very unconstitutional taking of land. And it's one that I definitely don't feel I don't feel that I will ever be compensated for. The family will not be compensated for this due to the loss of lots that we'll never be able to ethically sell.
Okay. Board Member Wagner has a question.
Okay.
Do you have any water crossings, or any water or
It crosses-
creeks that the pipeline would cross?
It crosses Walnut Creek Limited Partnership, or Walnut Creek. Yeah.
Okay, all right. And is that up in that forested area?
It's not really shown per se there, but it's there, but it's not shown. It's not pictured.
Okay.
I don't know.
Would it be in the same area as the forested
It might
areas?
trail off towards Highway 69 there, possibly. That could be one at the lines, but I think that's more of a gravel road. But it definitely crosses Walnut Creek.
Okay.
It would definitely be a low point in the pipe, and then the problem I mentioned of an explosive release on a low point in the pipe, which would amplify all of the problems.
And you mentioned that you thought that they would have the ability to raise it to 2,000 pound PSI. Is that?
I've heard that as speculation.
Okay.
I don't know if that's true, but my understanding is that without any authorization by you folks and the board, it could conceivably be raised.
Okay,
to
that's what I was
2,000.
asking, is where you got that information, but you said you just heard it.
Yeah, I heard
it's
that.
Okay, thank you.
Mr. Prey.
I only have a simple question for redirect. You mentioned that this is cropland. What is it that's grown here?
Corn and soybeans.
Is that, it's been continuous corn and soybeans? You haven't tried rutabaga or anything?
No.
All right. No further questions.
Witness may step down. Mr. Prey.
I call Sandra Feldstein to the stand.
Good afternoon. Please raise your right arm. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
And could you please restate your last name?
Feldstein.
Feldstein.
Yes.
Thank you. Mr. Prey?
Can you state and I guess spell your name for the record?
Sandra, it's Sondra. Feldstein, F as in Frank, Eldstein.
For the record, you are the landowner and farmer regarding the land we're going to be talking about today.
Yes, I'm the sole owner.
And has the Technology Bureau adequately located on that map?
Yes, that's the parcel. Now, for whatever reason, the way it's been platted, I actually also own the land to the south of that as well. But that's the parcel that the proposed pipeline's going across.
Okay. Are you the same person that previously filed written testimony in this case?
Yes, I am.
And I think you filed some objections quite a while ago.
Yes, I did written objections as well. That was way back in January of this year, I think, when they first started taking them.
Before I talk about that, do you have any corrections or additions to your testimony?
I do. 2 days after the deadline, filing deadline for this testimony, I got a certified letter from Dakota Access saying that they changed the route, and it is a completely different spot than it had been originally. It's almost twice as long as it was going to be originally, and it is much, much more damaging to my personal use of the property than the original proposal. It was that you see how it's kind of comes up to a point. The original pipeline was going to be kind of across that top point. It was going to cross a creek, which, you know, if I tried to do that, the DNR and the Corps engineers and EPA would all be breathing down my neck. They have an exemption, they can do stuff like that. And then it was going to take out some timber. They've changed it now so that it goes across the, what's basically what shows on that little arrow as the southern part of that, although, as I say, my property actually extends south of what they're showing there. As a result of which, it's going to take out all of the protective timber along the north side of that ridge, and the top of what on the property is a south-facing slope, which is a large part of the reason I bought it in the first place, because as a market gardener, it is an absolutely prime spot. The microclimate created by a south-facing slope with protection with trees on the north and trees on the west, it's a perfect spot to be growing vegetables, which is what I do. It takes out all of that. And contrary to prior testimony, which has said you can farm on top of it, well, it depends. If you were growing corn and soybeans, you can farm across the top of it. If you want to put vegetables on it, you can't. A lot of those things are perennials, like blueberry bushes and rhubarb plants and asparagus beds and fruit trees. I can't put any of that on an easement because they could come in and tear it out any time. All of which would have been in my original testimony if I had known, but they waited until 2 days after it had to be filed before they told me any of that.
I have a clarification question. You used the phrase market garden.
Yes.
Could you explain what that is?
It's growing fresh vegetables, essentially. They've been asking people whether or not they use petroleum products in my farming. Actually, I really don't. I pretty much do it all by hand. Iowa doesn't produce any oil. However, we also are a fresh food deficient state. We produce lots and lots of corn and soybeans. We produce very little of the kind of stuff that people actually eat every day. The kind of thing I grow is what people eat every day. I grow not soybeans, but green beans and tomatoes and potatoes and sweet corn and all the stuff that everybody likes to eat and actually put on their table, of which Iowa imports most of that kind of thing. It's people like me that reduce that deficit a little bit.
The other question, and I think most people know, what's a microclimate?
A microclimate is a spot where, for whatever reason, usually because of either natural or like a building. For instance, I've got an old, on the spot where we live, which isn't this spot. We live in a different spot right now. We bought this with the intention of building on this spot. I've got one of those old oval-shaped corn cribs. It's built out of concrete block. Concrete obviously absorbs heat from the sun. I can grow things on the south side of that building that I wouldn't be able to grow if it didn't have that building behind it. The south-facing slope does the same thing. Southern sun, it warms up faster in the spring than it otherwise would because it's getting a lot more sunshine. With trees, as it is here, along the north ridge and on the west ridge on the other side, that cuts down on the wind. Anyone who tries to grow anything in Iowa, we have really windy conditions. And for vegetables especially, reducing that amount of wind is really, really important to growing a good crop. It makes it a lot easier to grow things up on trellises. It just makes it a lot less likely to get wind burn, which is something I actually have a problem with even in like June. The wind can be strong enough that it will burn vegetable crops. On a spot like this, the microclimate that's there, none of that would happen. That's why I bought it.
You indicated you received the notice of the route change about 2 days after you filed the
I did.
testimony.
Mm-hmm.
The testimony you have as a file stamp in the upper right-hand corner, October 12th.
Yeah.
Do you know what day it was that you received the certified letter?
I think I got the notice of the certified letter on that Friday. I think the pipeline owns stock in Xerox because they always send me lots and lots of copies of everything. They sent me like 6 copies, so if you would like to see a copy of it, it's dated the 15th of October is the day the surveyor put this on here, although it says it was drawn on the 7th or the 1st of July, but I didn't get it until October, and it in fact says that on here because it's dated the 15th of October. Would you like a copy of this?
I can.
Do you want a copy of it? I have lots.
I can file that electronically, and if Ms. Feldstein has a copy, she could tender to
Yep.
opposing counsel for any cross-examination. It's their document, so
Yeah, they created it.
Can I see that?
You want another copy? They sent me 6. I brought 3, so.
Will you put up our Exhibit H that we have on file for Jasper County? I want the, that is the, I want the, click on the, can't she just click on the, oh.
That's the original one. That's not the one I got. That's not the one I just gave you.
Mr. Prey, I have a housekeeping measure.
All right.
Just a moment. Mr. Dublinsky, can you assist me in identifying for me how the board would know if a change was made? Would a new filing have come through?
Yeah, there should be an amended Exhibit H.
Lois, will you look up in EFS and what's the date on that? Mr. Dublinsky,
Yes, Your Honor.
do you have someone available over there that can tell us when the updated filing was filed in EFS? And
We are-
we'll continue while we wait for that.
We are sending emails, have people look at that right now.
Thank you. Mr. Prey?
The only other question I have, you indicated, Ms. Feldstein, that you had filed some objections in the past that you filed with the EFS system.
Yes, I did.
Is there anything in those objections that's not in your testimony?
Well, yes. I mean, I went into a lot more reasons in that for why I think that, first of all, why eminent domain should not be granted, and contrary to Mr. Dublinsky's argument that I don't have any right to say my opinion on that, is from what I can see in the requirements for being on the Iowa Utilities Board, you don't have to be an attorney. Therefore, by his argument or his rationale, none of the people on this board should be able to decide whether or not eminent domain is applicable in this case, since there's no requirement that they be attorneys. So I think I have just as much right to say something on this as any other citizen does. As has been mentioned earlier, the statute says that you're supposed to give eminent domain if it promotes the public convenience and necessity. I don't see how that's going to happen. One, because the likelihood of my insurance rates going up, especially if anyone did try to put any kind of house on that property. It won't be possible anymore, for instance, to put a well on it if that pipeline goes in, because it's going across the highest part of the property, and no one's going to take the risk of leachate from the pipeline getting into their well. It will decrease the value of my land a lot, because I won't be able to use it for the purpose for which I purchased it. I can still grow hay on it, which is what I'm growing on it right now. I can still put cattle on it, but I will not be able to use it for market gardening, which has a much, much higher per acre return than either hay or pasture land. I do not see where the Iowa Code provides any real mechanism for assessing damage. In fact, hay and pasture ground is not mentioned, nor is market gardening. All they really have is row crop in the statute. So there isn't any good way to assess what the damage during construction might be. There is no long-term economic benefit to it. You get some short-term jobs, and as I understand, you put together short-term jobs, you get a career. It doesn't, however, make any long-term benefit. There is no cleanup money in Iowa Code. The $250,000 surety bond is a joke. The pipeline has spent more than that on this hearing. And it would go nowhere towards cleaning up an actual spill. There is nothing in here that provides any money to places like the Colfax Fire Department, which is who would be responsible if something happened. And I can tell you right now, they are not up to snuff on pipeline spills. None of them are. There isn't any reason why they should be. When I went to the informational meeting last December, I think that the pipeline's response to that was, well, we would have some equipment stationed at places around the state. Well, how long is that going to take to get someplace? And who's going to find the leak in the first place? Because as a practical matter, when these pipelines leak, there have been several of them, it's usually the farmer who goes out and finds it. It's not the pipeline that discovers that that pipeline's been leaking. It could go on for who knows how long. There is very little regulation on these pipelines, partly because it is going through rural Iowa. It's considered a low hazardous place. The soils of Iowa, which are unique to the world, took 10,000 years for Mother Nature to build them. They've given no value in federal regulation when it comes to any, in fact, there isn't any regulation required, any kind of monitoring required, because there's no people living close to this pipeline, or at least not dense enough population to make it come under the regulations in federal code. The chances of surface water contamination are pretty great. The way they've got it, for instance, the rerouted route that they've put across my land, as far as I can tell, they're planning to use an existing culvert that goes underneath the road that takes a creek through there, which means they're going to be putting the pipeline right next to, or at least right underneath, I'm not sure which, an existing creek. It goes straight into the water supply. And the notion that this is contributing to energy dependence is just a joke. There is no requirement that any of this fuel stay in the United States. That's why they want to ship it down to the Gulf, because that's where the refineries are. The refineries are there because that's where the ocean-going ships are, so they can take it anywhere in the world, wherever they're getting the best price.
Mr. Prey?
I don't believe I have any further questions.
Mr. Lozier?
We have no questions.
Mr. Piazza?
No questions.
Mr. Dublinsky?
Thank you, Your Honor. I do have a few. Is it Feldstein?
Stein.
Stein. Thank you. Ms. Feldstein, did you tell the Dakota Access land agent that you had a market farm on that property?
No, because I haven't put it there yet.
Did you suggest?
Wait a minute. The Dakota Access agent, I can tell you, she calls my husband all the time. I tell her every time she does that, call me. And the next time we get a message, it's on his phone, which sometimes he's in the country, oftentimes he's not. I set up a meeting with her. It was this summer sometime. She was supposed to be there at 10 o'clock in the morning. It was raining like it did most days this summer, so I was in the house. 10 o'clock comes and goes, and 11 o'clock comes and goes. I finally, at 2 o'clock, I actually had the car keys in my hand because I had someplace else I had to be. She shows up in the driveway. And I said, I'm sorry, I can't talk to you now. I have to leave. She says, well, I called and left a message. Well, she'd called my husband again for the 5th time after being told repeatedly to call me. My husband was on a plane to China, or maybe it was France. I don't remember. At the time, he did not get that message. If she wants to talk to me, she should show up when she says she's going to, and she should call me, not my husband. My husband isn't even on the deed to the property. I haven't heard from them since. I never heard anything after the proposed. All I got was the usual mailing that says sign here. It never mentions the fact that I have a choice. It just has a place to sign.
Just to be clear, at the beginning of that, and let me rephrase it. Have you or your husband told the land agent about the intent to have a market garden or market farm there?
She's never asked me what my purposes for the land are.
That wasn't my question. Have you told, or your husband told the land agent of that intent?
No.
Okay. In fact, on around September 2nd of 2014, did either you or your husband tell a land agent that you wouldn't sign for anything?
I told him I was not interested in signing an easement.
So you have talked to her?
I think that was through an email, actually. I have spoken to her on the phone, and I spoke to her very briefly in person when she showed up at my house finally 4 hours late.
Have you told, or your husband told, a land agent a preferred route that you would have across your property?
A preferred route?
Yeah. If there's a route that would work better for you, have you let anybody know that?
They only ever proposed one until they changed it.
My question is, have you told them if there is a location that would be better with regard to your plans for your property?
They never asked. They told me where they wanted it to go. I never had any notion that I had any right to argue about where it was going.
The change in the route moves from a diagonal cross of your property south to running along the property line, correct?
It's not actually the property line. I should say the parcels, for whatever reason, were platted separately. It's not my property. I mean, the line that it's going on now is not my property line. It's right through the middle of my property. I own the land to the south for about another 1/8 of a mile. The gray area there that's underneath the black triangle that's still on the one side of the road, that's all mine. Yeah.
You talked about the higher per acre return on the market farm. You're not engaged in that activity presently, correct?
Yes, I am, not on this property.
Okay. Do you have a figure for how much higher the return per acre is as a market farm as opposed to the hay or pasture operations?
I easily clear $5,000 an acre on a market garden.
What is the 5,000 is an average?
It depends on what crops you choose to concentrate on. But what I've done is a diversified market garden, meaning I grow lots of different things, which probably has a lower return per acre. I mean, people who are concentrating on one crop can probably get even more than that. But yes, that's what I make as a market gardener. I ran a CSA for a number of years, which for various reasons, I'm not doing that anymore, but I'm still selling vegetables.
Year over year, what's sort of a high and a low range for your return on market farm property?
It's been pretty steady because I do a lot of my marketing through, or like I said, until recently, I did most of my marketing through what's called a CSA, which is a community supported agriculture. And so people buy shares. And so I can pretty much, one of the advantages of that is I can pretty much guarantee my return before the season starts.
On the piece of property shown on the screen there, you do not have any traditional row crops, corn or beans.
No, that south-facing slope that I told you about, it used to be, before I owned it, was in, but in my opinion, it's a bit steep for that sort of use, and it's in grass now.
So just to confirm, nowhere on that property are there corn or beans?
No,
And haven't been for how long?
not since I've owned it. I've owned it for 8 years.
We have nothing further, Your Honor.
Mr. Pauly,
No questions.
Ms. Jacobs,
No questions.
Mr. Wagner?
Yes, I have a couple.
Mhm.
Good afternoon, Mr. Feldstein.
Yeah.
This map doesn't depict where the current projected route is that correct?
Right.
It goes along this, what would be the
It
south?
would be the black line of that gridded
So it would be,
triangle there.
yeah, it would be
Right.
between the two properties that you own.
Mhm.
And you mentioned that there's a culvert. Is that go along?
That's at the road on the east.
Oh, okay. So
Yeah.
that doesn't stretch along the entire
No.
south of
There's
that property.
there's a creek that goes. They would have crossed it with that, but it goes then down to the east and it runs underneath the road. And like I said, as far as I can see from the new route, that instead of crossing it now, they're just kind of paralleling where it goes under the road.
Okay. And so when you mentioned a south-facing slope that you had intended for the market garden, is that the correct term?
Yes.
Is that where that south-facing slope is located? Is along the southern?
Along where the new route is, which is
Right,
the
right.
southern border of that
So
triangle.
So this route was preferable to your
Yeah,
property.
I mean, it was
than-
less destructive. It was also a lot shorter. Yeah.
Okay, thank you.
Ms. Chair, point of clarification. The visual, I just would like to know, with respect to the pipeline and the adjacent parcels that apparently are not subject to eminent domain, what was the date of this map? Okay, as I see a map dated November 13, 2015.
Yeah.
I just would like to know if it could be clarified, Your Honor, about the adjacent parcels and when they were signed up to this parcel that Ms. Feldstein?
Yeah. To my knowledge, the one to the west was never signed up. That's part of the reason they changed it.
And I apologize, that might be friendly cross, there might be an objection to that, but that would be my suggested line of questioning.
Mr. Murray, I understand that you are making an objection as to whether or not the board can provide you with information related to the updates on the maps. It is my understanding that the electronic filing system can provide you with a continual update of progress of signups for voluntary easements as we receive the new map updates. Therefore, the dates on the maps that you're seeing are updated every day when we get the new filings and have the date of the most recent county overview map. Some of the, if those properties were signed up after she received her route map, you should be able to go onto the electronic filing system and find those dates. I'm not an electronic person. I rely on somebody at my house for that. So that's how you find it. Does that answer your question?
Yes.
Thank you. Ms. Feldstein, I am going to ask you some of the questions that I believe you have not answered so far. Mr. Prey, I would like clarification that you did ask her to adopt her objections so that they become part of the record, correct?
I hadn't quite gotten to that stage.
Okay,
I
well, I'm
guess,
going
so.
to do that.
All right.
So, Ms. Feldstein, do you adopt your objections? And your response
You
is?
mean the testimony or the objections that I filed to the
Your
board?
testimony is adopted and accepted. Are you asking me to adopt your
Yes.
objections?
Yes.
They are admitted. We've reviewed your county map. We've reviewed the use of the property. You have, does your property have drainage tile or other installations?
Not on the proposed route,
On the current proposed route or the old?
on either of them.
On either map. Does any of your property have any other natural gas or other pipelines?
No, it does not.
Does the pipeline cross any other waterways other than those that you've described?
No. Marshland, but not actual waterways.
And can you tell me exactly what you're looking for in terms of relief from the board related to your property?
I would like you to deny the request for eminent domain.
Mr. Prey.
I just want to make sure one thing's clear. The map that you have in front of you,
Is not accurate.
that was going to be my question. The date on that map is apparently, I believe it was November 15th.
Yeah, which is a month after they
Mr.
sent the
Prey,
date.
we understand that
Okay.
this map is not accurate. We also understand that we do not have the current Exhibit H filing.
All right. As a housekeeping matter, I guess I could pose a question to Dakota Access. Are they planning on filing that new route map on the
They
property?
have indicated previously that they are emailing to find out when that was filed in our system.
All right. And I assume that that will, do I need to make a motion to have
I'm pretty
that?
sure that it's not necessary, and
Okay.
I will take care of it.
All right. I don't have any further questions.
And let me restate that. I will take care of that.
So we can assume from a legal standpoint that that means that the board will add that to the official record of this hearing.
Yes.
All right. No further questions.
You may step down.
Thank you.
Your next,
My next witness is Keith Rook.
Good afternoon, Mr. Rook. How are you today?
Good.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
You may be seated.
Mr. Rook, can you state and spell your name for the record?
Yes, Keith Rook, R-O-O-K.
For the record, are you submitting this testimony on behalf of another person?
Yes, my father, he's getting older, and with his health, he couldn't make it here, so that's why I'm here.
Just to be safe, we filed testimony by him, yourself, and your brother.
Right.
Okay. And have you been able to, or can you look at the map that's been put on the screen there and just note whether that accurately portrays the location?
Yes, it does.
Are you the same person that previously filed written testimony and exhibits in this case?
Yes.
Do you have any corrections or additions to that testimony?
No.
Move that the exhibits attached to the testimony be entered and tender the witness.
Mr. Lozier,
We have no questions.
Mr. Piazza,
No questions.
Mr. Dublinsky,
No questions?
Mr. Pauly,
No questions.
Ms. Jacobs,
I have no questions.
Mr. Wagner, Mr. Rook. Hello.
Hi.
I'm going to ask you several questions. The first is to verify that the property that's been identified in the map on your screen is the property in which you have testified.
Yes.
And is the location of the pipeline route correct?
It appears to be.
Thank you. What is the use of the property?
To grow corn and beans.
Is any of it pasture land?
There's no pasture land. It's been in continuous corn and beans since I was a little kid.
Do you have any plans for different use of the property in the future?
I don't, but my father does own it.
I understand that. To best of your knowledge, does your father have any other use, intended use for the property in the future?
Not to the best of my knowledge.
Okay. Does the property have drainage tile or other installations?
Yes, it does.
Do you have any natural gas or other pipelines on your property?
No.
Does the proposed pipeline route cross any waterways?
Could you define waterways?
Does it cross any creeks?
No.
Does it cross any marshland?
No.
Is there any other definition of waterway that you're thinking of that I would not state?
Well, in farmers' terms, they have waterways through field that take off the excess.
Keep going.
Okay, I thought you shut me off.
No, I didn't.
Okay.
It's just my hand moving the way I
Okay.
do.
In farmers' terms, the waterway takes excess water that when there's excess water, excess rain, but, you know, it's not a continuous flow.
Is there any timber on the property?
No.
Can you tell the board your precise concerns with the proposed crossing other than keeping it to what you've listed in your testimony?
Sure. The parcel is very flat, and it has tile lines running from the north to the south. And the proposed pipeline is intersecting all of those tile lines.
Okay. And as it relates to your property, can you tell me exactly what you're looking for in terms of relief?
Yes, I can. I think to deny eminent domain, this has been a family farm since the 40s. It's a private business, and I don't think another private business should be able to change that.
Okay. Do you have anything else you'd like to tell the board?
No.
Mr. Prey,
No further questions.
you may step down.
The next witness, if I may. I will be
Miss-
calling.
no,
Sorry.
No, I
Oh,
said no.
okay,
I didn't
sorry.
have my mic on.
Okay.
Mr. Prey, Mr. Puntany, you've kind of taken over Mr. Hannigan's spot, so I would ask if Mr. Hannigan could please sit in Mr. Swinton's spot and you move his name tag down. So I've done that, Mr. Hannigan, and now here's where we're going to end up. Mr. Dublinsky, you're on notice that we are going to be addressing both the motion and the objection. We're going to take a 10 minute break. When we come back, that's what's before the board, and we're going to hear both parties, and we will make a ruling then after we've had discussion based on your motions and objections. Do you have any questions?
I do not, Your Honor.
Mr. Hannigan, do you have any questions?
I do not.
All right, we will take a 10-minute break. For the information of all of the other parties, and I don't even know if this is what Mr. Dublinsky was referring to. It doesn't really matter for the record, but we have a number of filings that were going on back in the electronic filing system related to a motion that Mr. Hannigan is wanting to make and objections that Mr. Dublinsky is wanting to make. We are going to have each of those parties make their motion and objections. We have the documents. The board's going to review those, and then we're going to make a decision. So, Mr. Hannigan, you may state your motion, and we have both of your filings. So we have a motion to admit later filed evidence, a Dakota Access resistance, a motion to admit later filed evidence, a second one that was filed. Were they both filed today?
No.
Yes,
No, the original motion was filed on November 19. It includes an affidavit of a affiant who is the farmer of the real estate.
No. And then a reply that was filed yesterday.
That's true.
Okay, could you please state for the record the requests that you're making?
With respect to this motion, our client is Marion D. Johnson and her agent, Verdell Johnson. And what we're asking the court is, in recognition of having admitted Marion D. Johnson as an intervener in these proceedings, following a decision of the district court in Cherokee County, that she be allowed to make her case. Now, this case is largely a law case, but there are a handful of necessary facts to be established. One of those necessary facts is that Marion Johnson is the owner of agricultural ground. Now, the question seems almost a given in this issue perfunctory, but we need to make a record on it. And there's two ways that we can do this. And we can either admit this affidavit of Verdell Johnson, who is the farmer and the spouse of the landowner, or we can ask Mr. Johnson to appear before the board, which he's willing to do, and we can take his oral testimony in this regard. The objection to this is that it is...
I'm going to allow him to state his objection.
Oh, certainly, certainly.
Do you have anything further for the board?
Yeah, what I have is that because she and he are interveners, they have a special status above just other landowners. And when the court ruled that they should appear here, and when the board graciously allowed them to intervene, that includes the opportunity to make their case. In other words, it's not much of a benefit or a reward to them to allow them to intervene and have them not make their case. And it requires from their testimony one very simple fact, which is that they own farmland and that the proposed pipeline route will cross their agricultural land, as that term is defined in Chapter 6A.
Mr. Dublinsky?
Thank you, Your Honor. And I am a bit at a disadvantage. I will admit to the chair that I have not had the opportunity to read the reply. We've had a few other things on our plate for those of us that have actually been attending the hearings. And most of what our objection is in the brief, but I have to address Mr. Hannigan's comment that interveners have a special status that includes making the case. Otherwise, intervention is not much of a reward. Intervention is not a reward. The board could have, and frankly, in our view, should have, rejected the intervention. Mr. Hannigan's clients were allowed to intervene 3 months after the intervention deadline, and specifically told that in exchange for being able to come in that late and still be granted intervention at all, that they needed to take the schedule as they found it. In our view, the board has actually already ruled on this motion. In the intervention, the board very clearly said they must take the schedule as it stands, which means their participation can include cross-examination of adverse witnesses and presentation of legal argument. In the original, at the time that order came out, nothing more was said about it. It wasn't until after we were in hearing and our side was all tied up in the hearing that they decided now they wanted to get a second bite at the apple, and having gotten their foot under the, in the door, now wanted to push back on the board for additional status. Again, the board has already ruled on this specific issue and said no. There is no entitlement to file by affidavit without cross. There is no entitlement at this late date to put on a live witness. It would be highly disruptive. It would be a delay, and there would be no prejudice, because this is essentially what you have is an intentional litigation decision that the board is now being asked to relieve a party of. Several parties, both filed in Cherokee County and intervened by the date that the board set here. Other parties decided, for whatever reason, perhaps they thought it would undermine their own case if they did that, to file only in Cherokee County and sue the board. Having made that choice, it is not the board's job to save them from their own litigation strategic decision. We have a case to that effect in our resistance brief. But at this point, the board has been very clear in orders between that intervention date and today that everything will be done by pre-filed testimony, number one. You've told people that wanted to show up here without pre-filing testimony in some way that no, that doesn't work either, that you have to both pre-file testimony and be willing to take the stand. And you went one step further with Johnson and said, and if you're going to get in the case at all 3 months after the intervention deadline, you have to take the case as you find it. There is no compelling reason, and certainly none that wouldn't work extraordinary prejudice on Dakota Access, for the court to change its opinion now, particularly when we haven't had time to fully research the reply and frankly haven't had time to fully research exactly what the implications are of what he's asking. He wants us to essentially stipulate or talk the board into essentially stipulating for us a key factual predicate of the legal appeal that they're trying to set up of this decision. They're just not entitled to that assistance with their case, particularly at this late date.
Mr. Hannigan?
About the question of prejudice and whether Dakota Access could possibly be prejudiced by this. The question is whether or not Marion Johnson owns agricultural ground. Dakota Access, of course, knows whether she owns agricultural ground, and they know that she does because they've researched the entire route and their agents have approached the landowners. And so the question of whether there's agricultural ground is number one, not a mystery, and number two, therefore, no prejudice to enter that fact into the evidence. And the board's order on the intervention expressly provides that they would be allowed to make their argument and their case under Section 6A21, which requires really only two facts. From the landowner, the fact is required that it be agricultural ground, which is proven either in a 2-page affidavit or through 5 minutes of oral testimony from the affiant here, Mr. Johnson, on Monday the 7th or Tuesday the 8th, which he's willing to do if the board would like him to come here to do that, and which would allow Dakota Access to cross-examine him about whether or not crops are grown on his farm. So the question of whether there's prejudice is there simply cannot be any meaningful prejudice. And the question of whether or not he's entitled to make that argument under the board's order about his intervention is already answered in as much as the board said that he would be allowed and that his spouse would be allowed to make their 6A21 argument. The other relevant fact or set of facts about their argument are all relative to Dakota Access, and it's our belief that those facts are already in the record.
Madam Chair,
Mr. Puntney?
I don't wish to prejudice my own case, but under the rationale that...
Is this related to
Yes,
this
it
issue?
is. This is exactly...
This is not,
No, this is a question of clarification, okay?
okay.
I also did not file expert testimony. I did intervene in a proper manner and met most of this, and you are allowing me to testify as an intervener in that, you know, as I understand the rulings of you know, so far to date. So I'm just trying to clarify, is this going to prejudice my testimony in some fashion if the ruling goes against Mr., you know, what is being asked, you know, for them to be allowed as an intervener to come in and testify? I'm just trying to protect.
How do you think that it would prejudice you?
Well, as I understood what Mr.
You're,
Dublinsky
you
was
are
on.
scheduled to testify on Monday. That is not changing.
So this has nothing to do with me.
This has nothing
Thank
at
you.
all
That's
to
all.
do with you.
That's fine.
All right. Our intent right now is to move to the next witness, and I'm going to ask Mr. Prey to call the next witness. And we are pulling our orders so that we can read the same. And we will keep moving forward. Mr. Hannigan,
Yes.
would you like? You need to stick around.
I will stay until you need me.
Mr. Prey,
I call my next witness, Rebecca Wehrman Anderson.
Ms. Wehrman Anderson, do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Can you please state and spell your name for the record?
Rebecca Wehrman Anderson, WEHRMAN hyphen Anderson, ANDERSEN.
Are you the same Rebecca Wehrman Anderson that has prepared testimony and exhibits in this matter and filed them?
I am.
Do you have any corrections or additions to your testimony?
I do not.
I tender the witness and move that the exhibits be entered.
Mr. Lozier,
No questions.
Mr. Piazza, Mr. Dublinsky.
No questions?
Mr. Pauly,
No questions.
Ms. Jacobs?
I have no questions.
Mr. Wagner? Good afternoon.
Good afternoon.
Did you file any objections in this docket?
No, I did not.
Do you own any property?
No, I do not. Not in the pipeline area.
Mr. Prey?
No further questions. And for the clarification, this is an expert type witness, not a landowner. So I'd like to call my next witness if necessary.
Thank you.
The next witness I'd call would be Dan Rasmussen.
Hello, Mr. Rasmussen.
Hello.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
You may be seated. Mr. Prey?
Can you please state and spell your name for the record?
Dan Rasmussen, Rasmussen.
Now, there are several Dan Rasmussens. I think there may be another one even in this case. Can you explain just who are you? What do you do for a living?
I am a drainage contractor. I install tile for around on the farms.
And have you prepared and had filed written testimony and an exhibit into the record in this case?
Yes.
Do you have any corrections or additions to that testimony?
No.
I move the admission of this, the exhibit and the testimony tender the witness.
Mr. Lozier?
No questions.
Mr. Piazza? You may.
Thank you. No questions.
Mr. Dublinsky? Ms. Agramonte?
Thank you, Your Honor. Mr. Rasmussen, my name is Lisa Agramonte. I'm counsel for Dakota Access, and I have some questions for you this afternoon.
Okay.
You're testifying here today on behalf of Laverne Johnson. Is that right?
Yes.
Is he paying you to provide this testimony?
No.
Have you done a fair amount of work for Mr. Johnson in
Yes.
the past? How much has he paid you to do tile work on his land?
In the thousands. I don't. It's been over the years.
Tens of thousands?
Yes.
More than 100,000?
No.
More than 50,000?
I don't think so.
Have you done all of his tile for the last, let me ask, how long have you been doing tile for Mr. Johnson?
I don't remember 15 years.
Has anybody else worked on Mr. Johnson's land in that 15-year period installing tile?
There's another contractor that installed a larger main on his ground.
Do you know when that was installed?
I can't remember what year that was.
Do you know the name of the
04.
contractor?
John Williams.
What would a main like that cost?
$60,000, maybe $70,000.
Are you a geologist or a soil scientist?
No.
Let's go to page 2 of your testimony, line 12. You referenced the installation of a 24-inch pipe.
Yes.
How
That's
big is that pipe on the exterior?
about 31, 32 inches.
That would be bigger than the pipe that's being proposed for this project, right?
Yes.
On line 19 of page 2 of your testimony, you talk about the impact of the project on Mr. Johnson's drain tile. Is that right?
Yes.
Have you ever been hired to repair a cut or otherwise damaged drain tile?
Yes. Oh,
Are those repairs pretty routine in your business?
we have, yes.
Is it your belief that once you or someone in your industry makes a tile repair, that the ground will be restored to its normal functioning?
The tile was installed to remove the water to help it along, and we try to separate the black dirt and the clay.
I think I asked a bad question. Let me try that again. I appreciate you bringing up the soil separation, and I will have some questions about that. When you make a tile repair, is it your belief that that tile operates as well or better than it did before there was damage or a cut?
We try to put it back to original condition.
All right.
Many of our tiles are 100 years old.
When you go out and talk to farmers about damaged or cut tile, you would represent that you can fix it, right?
Yes.
Have you ever been hired to work on a pipeline project?
Yes.
Are you familiar with Chapter 9 of the board's rules?
No.
All right, on your direct testimony, you make a statement that Dakota Access will have no incentive to properly remove and replace the topsoil. Do you recall that statement?
They do a fair job.
Okay, but your testimony was that they would have no incentive. Upon what do you base that on?
I guess I might.
Let's get the testimony up so maybe it'll refresh your memory.
When it does this, because I have been on the pipelines, after they have been done, it is not as good as Mother Nature. It's hard to separate the systems out.
Okay, but I'm really trying to explore the specific statement you made on lines 2 to 4. And you state, you are concerned that Dakota Access will have no incentive to properly remove and replace the topsoil on Laverne Johnson parcels during pipeline construction. And I would like to know upon what basis do you make that statement?
Objection. It's not what the statement said. Had the word concern. I don't think I heard that.
Please
Line 2.
restate the question.
Certainly. Your testimony is that you are concerned that Dakota Access will have no incentive to properly remove and replace the topsoil on Laverne Johnson parcels during pipeline construction. That's what your testimony says, right?
Yes.
What is the basis for your concern?
I guess I'm not quite sure what to say.
Okay. Did you write this statement?
I had help.
Who
I'm not
helped
quite
you?
this wordy. Yes. Mr. Frey.
Would you, yeah. So are those Mr. Prey's words or yours?
No, I am worried about that.
You
'Cause we
worried?
don't-
Sorry, go ahead.
We don't get our construction back to original systems.
Okay, but I'm focusing specifically on Dakota Access's motive or incentive, which is what you stated in your testimony here, right?
Yeah.
Okay, so what basis did you question whether
I
Dakota
guess
Access?
I don't
sorry,
have any. I don't
you-
have any basis then.
You don't have any basis? Thank you. When you worked on the pipeline project, what kind of pipeline project was it?
Natural gas.
Is that an interstate or intrastate pipeline? Do you know?
Inter.
Inter? Is that the only pipeline you've worked on?
Yes.
All right, let's go back to Mr. I'm sorry. How long ago was that pipeline project?
I did for Michael's pipeline, I had to repair tile for him. That was last year. And then we had another system 10 years ago. I did all the tile repairs for him.
All right, do you believe you did a good job on the tile repairs for Michael's?
Yes.
And that those systems you repaired are working properly?
As good as they can go.
Would you agree that Dakota Access is bound by Iowa law to segregate the topsoil and the subsoil?
Is there a law?
That's all the questions I have.
Mr. Pauly?
No questions.
I would like to remind the parties that I have, that the board did issue an order allowing Mr. Puntany to cross as it relates directly to his tile map. Mr. Puntany, please keep your questions to the issue the board is ordered.
Thank you. Mr. Rasmussen, have you done work for me in the past
Yes.
on multiple farms?
Objection.
I'm trying to establish his
Your Honor made a very clear ruling that this witness could establish the foundation for the tile map, and that Mr. Rasmussen made it not to explore his relationship with Mr. Puntany.
Would you like me to rephrase?
Yes.
Thank you. Are you aware that I have a farm that is proposed to be crossed by the Dakota Access pipeline?
Yes.
Have you been on that farm to do tile work for me previously?
Yes.
Were you asked in January of this year to again look at that farm to prepare a proposed tile map for that farm?
Yes, and we did make a tile map for that, for the ground and system on there.
Can you explain the process you used to do that tile map relative to this particular piece of ground?
We made the tile map so we can improve the ground, and also we have a problem with our neighbors who has not gotten his tile at the proper depth yet, and we need to plan for a future depth of tile.
Are you referring to the outlet?
Objection, Your Honor. Now he's asking about his neighbor's land.
No, I'm not. I'm trying to clarify that he's referring to an outlet issue that exists on the land.
It goes across your land.
Yes. Okay.
Miss Agramonte, I think just let us get through this and we'll be done with it.
Yeah, Your Honor, we would stipulate to the entry of this map as being one that Mr. Rasmussen prepared for Mr. Puntany. I thought that was the purpose of this discussion.
It is the purpose. Mr. Puntany, does that?
Yeah, if they stipulate that Mr.
Yes.
Rasmussen properly prepared the map, then
I'm not vouching for the document. I'm just stating that he prepared it.
then I would ask one more question. Is this map prepared using what is normal practices for you that you have done as a tiler for a number of years?
This is what we do for tiling. Yes, we prepare it like that.
Then I would move to enter this map as part of my exhibit. I can wait and do that at the time that I testify if you would like.
Yes.
That would be fine.
All right.
Thank you very much.
Ms. Jacobs?
I don't have any questions. Thank you.
Mr. Wagner?
Mr. Rasmussen, you said that you installed the 24-inch main that's on...
No.
Oh, you did not?
Yeah, another contractor did that.
Oh, okay.
I went from there and had to do the other systems, the smaller systems.
All right. My question revolves around the installation of that, so I will ask Mr. Johnson when he comes up.
But I was around when that tile was done.
Okay, well, I'll ask, and if you know the answer, you can. I think in your testimony, you said that the soil was segregated.
Yes.
And do you know, have you read any of the agriculture, the AIMP in this case, that was filed by Dakota Access, which is the mitigation plan?
No.
Okay, so you wouldn't have any idea whether or not you followed the same practices that they're going to be required to follow?
No.
Or the installer, not you, but the installer?
Yes.
Okay,
No.
so if you were around, did you segregate the soil? How was the soil segregated?
This project was a tough project because it was a flowing sand underneath, and so it ended up to be over 100 foot wide.
And so when you segregated, did you segregate the
The
top
black
soil
was pushed
from?
off farther.
Okay, so the
All of
top
the
soil
top.
was from everything else, or was there three?
Yes. No, it was basically, it goes right into a sand.
Okay. All right, thank you.
Mr. Rasmussen, one of the things that I've been trying to have information provided to me on is the process that's using the ag mitigation plan and also the county supervisor's involvement in this process. And as I have learned, the county supervisors are able to hire an inspector who then will assist and make sure that if there are any concerns with the manner in which the, for instance, tile lines are repaired, should they, and located, that a process will be followed to make sure that they're put into the same condition should the proposed pipeline be approved. Have you experienced that process in any of the other projects?
Not in the other, we've just finished a windmill project where we have a lot of underground electric lines, and we're having some issues. But and I'm dealing with our supervisors because I do farm as well too. And we are trying to figure out for our future use, because once a pipeline is in the ground, it's a immovable structure, and water goes downhill. And if I can't get my grades to go under, and then I can't get improvements going over. And so we have to kind of plan that out too.
Do you know whether or not the Jasper County supervisors have approved an inspector?
I'm in Webster County.
Webster County, excuse me.
They have talked about it. I can't remember whether, I was talking to my supervisor just the other day.
Mr. Prey?
No further questions. Tender, I guess I'm ready to ask for my next witness.
Mr. Rasmussen, thank you.
My next witness is Laverne Johnson.
Hello, Mr. Johnson.
Hello.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
You may be seated. Mr. Prey?
Mr. Johnson, can you please state and spell your name for the record?
My name is Laverne Ivor Johnson. I'm a corn and soybean farmer. My legal address is 241 J Avenue, Pilot Mound, Iowa, 50223-0127.
And how do you spell your name? I think you have a large V in Laverne.
Yes.
You also go by Vern.
Yes.
And your last name is spelled how?
My last name?
Yes, you know, it's an S-O-N at the end instead of
Yes.
okay.
Mhm.
And you're filing this, you prepared testimony on your own behalf. You own this farm?
Yes, I have.
And you're the same person that previously filed written testimony and exhibits into the record in this case.
Yes.
Do you have any corrections or additions to your testimony?
I don't believe so.
I move the admission of the attached exhibits and then tender the witness for cross-examination.
Mr. Lozier?
No questions.
Mr. Piazza?
No questions, Your Honor.
Mr. Dublinsky?
I do have a few, Your Honor. Good afternoon, Mr. Johnson.
Afternoon.
You did not, at any point, give voluntary survey permission for your property, did you?
No.
You only allowed surveyors on after a court ordered you to, correct?
I did not allow them on. Judge Haney allowed them on.
And have you either been here or watched the video parts of this hearing?
I've been here, some have not watched the video, no.
Have you heard your attorney ask Dakota Access witnesses if they had seen the tile maps that you provided as exhibits in the Boone County court case?
I heard one day one day when I was here, I saw those tile maps. Mm-hmm.
And Mr. Prey is asking it that way because you never gave those tile maps to a land agent, did you?
Never asked for them.
And you never gave them to them to say, here's what the tile looks like on my farm, you ought to know this, right?
Interesting enough, I did ask Jennifer Beck why Dakota Access had never meaningfully negotiated with me. And she said I was too intimidating. And I asked Jennifer if she wouldn't talk to my wife and my grandchildren because they can wrap me around their little finger.
Do you believe that you've meaningfully negotiated with Dakota Access?
No.
You were here just a few minutes ago for Mr. Rasmussen's testimony, correct?
Yes.
And was his answer correct that for the last 15 years, other than the main, that he has been the only tile contractor that's done tile work on your property?
That he, in the last 15 years? Oh, we've had, the person that has done the main has done some tile repair on the property from the previous tile. So he's been, as far as laterals, I believe that's correct, last, 12, 15 years.
And your main is at a variety of depths across your property, is that correct?
That's correct.
All of which are deeper than where this pipeline would normally run on the 48-inch depth minimum, correct?
There's so many tile.
Just talking about your main here.
The main?
Yeah.
Right there would be, do you want to put up that map? I think he's estimated the depth of it.
You don't recall what the
No,
estimated
I don't
depth?
recall.
That's
yeah,
okay.
You have to look at the comment.
And you agree with Mr. Rasmussen that the exterior diameter of that main is actually larger than the Dakota Access pipeline would be?
I would say so, yes. Mm-hmm.
And you have expressed concern because of the various depths of your tile about how the pipeline will be constructed through the tile on your property, correct?
That's true.
If Dakota Access agreed to bore the pipeline under your deepest tile, would you sign an easement?
You know, when I started out on this, I was neither for or against, I was neutral. The problem you have on that farm is you have an area underneath that tile that's, some people call it sugar sand, other people call it sea mud. It's like jello with oatmeal in it that hasn't set up. So when we put that tile in, we put in the tile that fits like this because we were afraid we'd lose grade. And so when we got to that sea mud, we jacked up the grade a little bit. And hopefully it'll hold. But there really isn't any in those areas. We pumped and pumped for days with a 2.5-inch pump to get the water down. It's really a difficult spot to get through. And I think boring, if you hit that, I think I don't think it'd be successful.
So just to be clear, even if we agreed to put the pipeline under your deepest tile and run under all of your tile across your property, you would not sign an easement?
Well, there are several.
Yes, it's a simple question.
Okay. I'll answer it this way. No, I do not plan on signing an easement if you bored under the pipeline. But there are other issues with that easement that would also preclude me from signing that easement.
No further questions, Your Honor.
Mr. Pauly,
No questions, Your Honor.
Ms. Jacobs?
Then I don't have other questions.
Mr. Wagner?
You always look at me like you're afraid to ask if I have anything. Good afternoon, Mr. Johnson. You just, in your discussion, you just mentioned that there were other issues that would prevent you from signing. What are those other issues?
Well, I think the first one that bothered me was the fact that the easement's in perpetuity. Every deal has to have an end, I believe. So I'm not going to grant anybody an easement in perpetuity. The second thing would be the constitutional. I think this thing is kind of getting rammed on me a little bit. I wrote a letter over a year ago. Well, I didn't write it. I had my attorney write a letter because I thought I would give them plenty of time to change the route. So I had my attorney write them a letter, Steve Hendricks, and said I wasn't interested in this project because I understood it at the start to be a voluntary easement. I even testified down at the subcommittee, joint subcommittee down at the State House. And at that subcommittee hearing, there was a person there from Dakota Access that basically poo-pooed the fact they were going to use eminent domain. The next thing I would say is really, and I understand Jennifer Beck's problem, but I have talked to Keith Leopard, I've talked to George Benavides, I've talked to Jennifer Beck, I've talked to quite a few people, and they've never really pushed that negotiation. They've offered me $26,000, and they've never asked me for a pipeline tile map. They've never asked me what my concerns are. So that's a problem. Another thing is, and it bothers me quite a bit, is James Fry. I don't see James here. The other day when I was here, he testified that Dakota Access is a pass-through company, and they really don't have any assets. And I think that's very difficult because we own our property fee simple. And if we're going to give somebody an easement that is a pass-through company,
Your Honor,
then how do we going to, go ahead.
I just wanted to clarify the record. That is not an accurate representation of what Mr. Fry said. Was it is a pass-through entity for taxation, which is true of nearly all forms of partnerships, from the ma and pa store down the street to the companies involved in this case. It's not a pass-through in the sense that
Mr. Dublinski is now testifying.
Your Honor, I'm just trying to clarify the record because it's being misstated by the witness.
He's doing a Keith Pateni standing, I guess, speaking objection.
Mr. Dublinski, I would appreciate it if you would allow the witness to finish commenting to Mr. Wagner's question. And I understand that you've clarified your perception of the presentation of the testimony by Mr. Frey. Do you have anything else to say as an answer to Mr.
Yes.
Wagner's question?
I would like to have you put up the plat map. I think it's, maybe Mr. Gray can. Is it Exhibit 1?
Might be one or two. I can check.
First, Mr. Wagner's going to finish asking his questions, all right?
Well, I was going to explain to him.
You're going to explain to him? Okay, then go ahead.
Yes, question.
I'm looking.
Is this the document you would like? No.
County plat map.
I think
You want the county overview map?
Yeah.
Is that right? Okay.
I think number 8 might be the map.
Yeah, go to
You mean
the
big-
Jasper County, correct?
No.
No.
No,
Boone.
Webster.
Boone.
Boone.
Boone
I'm
County.
sorry. I'm 3 witnesses ago.
Here you go.
Yeah.
It's the one where I have an exhibit where it's yellow.
Yeah, it's Exhibit 8
Oh, okay.
under
that 8?
Laverne Johnson.
There you go, right there. Yeah, Exhibit 8. Everything changes in life. What prompted the installation of the 24-inch pipeline? There is a 16-inch pipeline, 14 or 16-inch pipeline that was put in there in 1947. I've only had this farm since I bought it from my mother's estate in 2005. And what happened, that pipeline, before the neighbors to the north surface drained their property, if you notice one there, there's, I got just a second here. There you go. That's a little barrel. Yeah. Joseph Purcell, if you see that, the Burts own
Okay,
that.
and just for the record, I'm going
Okay.
to say that you're pointing at what will be property number 49, Joseph.
Yeah, where your hand is, right there.
Yeah, okay. Yeah, which is,
Okay. That property, first of all, that property drained, surface drained their property into a property there that's called Larry Frary's property. Then Larry Frary in turn drained it into my property. Well, can't stop water. So what happened that was probably barely adequate in the 47 drain now was wholly inadequate. So I thought, well, there's nothing I can do about it. There's few tile in the land north of me, in the prairie land or in the petro land. So I thought, well, what am I going to do? So I thought, well, I'll just fix it. So I put that 24-inch main in. That's what I did.
Okay, and you mentioned that there's a 14 or 16-inch.
Yep. Uh-huh.
Is
Yep.
that a tile line?
Yes.
Oh, okay.
Yeah,
All
that's
right.
a tile line too, and that's outlined on the tile map there. Yeah.
I think that's been adequately or
I think
repeatedly
so, too.
referred to in the hearing so far as well.
Almost ad nauseum.
Yes. So now you also, this will work. The
Now-
property to the right, which would be across, I
Right
don't know
there.
what that highway is, you also own that.
That's
And-
right.
And looking at the overview map of the county, it looked like it also it went across the northeast corner of that
Mhm.
property as well.
Mhm. Now here's the issue with that property. You see where it cuts right there. Right north of that property, I used to own that property. The north, about 21 acres there, just north of it. It would make that 60 into a full 80. So if we just take it up, but in that 21 acres, there's a 16-inch tile that goes right to a ravine for an outlet. It just curves right around there, if you lower your hand, just a little bit, right there. If it just curls around just like this. And then there's another 8 that goes right to the ravine on the northeast corner. Now, I bought this property in '92, and it's extensively tiled, but I don't have any tile maps on it. You're also faced with getting very close to the Frary's well on that.
And that would be the property that's just to the north. Now,
Just the property just
you
to the
referred to that as the Frarys?
Frary. Mhm.
And assuming that because of this map, it's not red, they have signed
They have signed
an
an
agreement?
easement.
Okay.
They own if you can go back to the previous exhibit we had, the pipeline comes right through the Ryder Farm, R-E-U-T-T-E-R, if you can put your hand over there,
Okay,
right there.
yep.
It comes right through there, and then goes through Larry Frary's, cuts the corner of Larry Frary's, and then goes down, following that line, and then goes down and cuts, yeah, you got it right.
Okay.
So there's another, just because I don't have a GPS map of the tile, there's a lot of tile in this farm. Yeah. It's been in the family since, or Johnson name since 1896.
And after you installed the 24-inch drain tile, I believe Mr. Rasmussen testified that you guys did segregate topsoil from non-topsoil.
We've got some pictures of that too, if you want to see them.
And is that property producing crops at the same rate as the rest of your property today?
Maybe we could see one of those exhibits. Could we see one of those exhibits, and I'll show you the problem.
Mr. Frey, could you help us identify maybe which exhibit that
We've
might
got
be?
2 or 3 pictures of those tile.
You want the
Exhibit
pictures of the
number-
installation of the tile?
Yeah.
Exhibit number 3 might help. It shows.
I
the
think that's
segregation.
correct.
There's a picture of that tile, of the main and how it lays in there.
Okay, and so
Now
the subsoil is on the left and the topsoil is on the right? Is that how that? Okay.
We took a dozer and dozed off, but the soil on this farm, and we can see another exhibit how deep it is. The topsoil in this farm is very, very deep. It's 4 foot deep. A lot of places a little more than that. So we took a dozer and we took it down to the yellow clay. Now, the issue is well, we got a couple issues with this. You see how the clay turns over there at the far end?
Maybe about where that
Yeah,
little
that's-
yellow stake is or something?
Yeah, that's blue clay. So what we have is blue clay under yellow clay. So it makes this whole area a bowl. Now, if we could go to the other one where the machine, which shows the tile machine.
Might be Exhibit 2.
There you go. This gives a picture of, see, he's not down too deep. Now, there's another picture there that shows
And
the
this
black
is,
dirt.
this is not the 24-inch, right?
No,
this is the
this is the 12.
the 12.
The
Okay.
12-inch, yeah. And you can notice the machine, how it's kind of tilted. It's going through some of that sea mud, trying to. We had to winch our way through that. And the dozer wasn't big enough to handle it, so we had to put the excavator on it. We had a heck of a time with it. Now, if you show them the other exhibit with tile machine, maybe we can.
That would be 6.
Yeah, there's another one. You see how we dozed the, or we took the black dirt off?
Yeah,
You see how deep that black dirt is? See, this is kind of an unusual farm to have that good of soil. It'll really raise corn.
Okay. And so back to my original question.
Okay.
After you've replaced all this and put the topsoil back, are those areas producing the same as where you have not laid tile?
No.
And how much of a difference would you say it is?
Well-
and how long has it been since you've done
Well,
this?
we, I put it down, the whole thing is in 08, but, so that'd be about 8 years, yeah. You can still tell where and we were careful. I mean, I give Mr. Rasmussen and Mr. Williams accolades because they were very careful to keep that, last in, first out deal, and still, we can still notice it.
So you can, do you do any GPS
GPS?
of your yield in your fields, or
Uh,
is there anything numerical that you can provide to the board, or rather than just you can tell?
You can tell in when you go across it with the yield monitor, but I have my yield monitor so it doesn't use up a lot of. I mean, you can set it down, I think, to 1 second or something like that, but mine isn't. Mine's set for like every 9 or 10 seconds. So in 9 or 10 seconds at 5-6 mile an hour, you go quite a ways. So if it would happen to read right on that spot. Now, there are yield monitors, and probably I should have set it at 1 second, but it uses a lot of memory then.
Sure.
Yeah.
Okay. All right, I think
you
that's,
can tell it on the screen, yeah.
okay, thank you. I appreciate it.
Yeah.
That's all the question I have for
Yeah.
you. And for the record, I have not found you to be, oh, you want me to do the rest?
Now, if you want to go back to the plat again, why?
I got a list of questions here. We've got that one. I mean, I'm trying to figure out where we at on our list here. Currently, do you have any other plans for different use of the property?
I thought maybe my son is probably going to take over this property, and he may want to put a hog building to the south of the. Who knows?
Okay. Yeah.
I mean, I'm not putting up any hog buildings. I can tell you that.
Okay.
That's too much work.
And given this map does show accurately where the pipeline is projected to cross, correct?
That's where they want to go. Yeah.
Okay. And we've talked very extensively about your drainage tile, so I don't need to ask you that question. Can you tell the board what you're looking for in terms of relief? What would you like the board to do?
Well, basically, I'd like the board to deny the permit. Or if you put up that plat of the, could you put up that plat of the county again, that one with the yellow on it?
Oh, sure.
Looks to me like they've got a clear path around me.
So the yellow on this map would be those that have voluntary easements? Is that-
Yes.
Okay.
Mhm.
All right.
The Ferries have given, they have voluntary easement on both those pieces, and Riders have given their, and also the Dorrance down there and the Crouches. They've all given voluntary easements.
Okay. Do you have any other pipelines other than a drain tile that you know of on your property?
No.
Any other easements?
I have an easement. This is another thing that bothers me, and the board could maybe help me on this. We have an easement that my father gave AT&T, and this is quite a few years ago, and they buried a transatlantic cable. Yeah, it's kind of big. It carries, I don't know how many conversations at once. It was the end of all, this was cutting technology. And we couldn't, have a generator over it, and we couldn't do this and that, which was okay, But he gave a voluntary easement for $500 on that cable. Now, when we go to tile and we call 811, because I always call 811 because I don't want to, affect anything, they won't even flag it. They said that cable is abandoned. Tile through it. Now, the issue is we've got this chunk of lead surrounding this cable in our farm, and it's 4 foot deep with 2 copper wires around it. So I thought, restoration. They're done with that cable. But I'll just have them come take it out. So I called Chip Baltimore, who's our representative here, and I said, Chip, how do I go? And I didn't know you folks did that stuff or what, but I know Chip pretty well. And I said, how are we going to why don't you take that cable out? And he told me that the reason they have abandoned it, but they won't release the easement because it costs too much to file with all the county recorders, the release of easement. And he said, you don't qualify for restoration because you give a voluntary easement. And believe you me, you put this pipeline in, it's a bigger deal than that cable. Now, I figured out how to get rid of that cable.
We don't want to know. I'm going to protect you from any future legal issues. We don't want. I know Mr. Prey would probably love for me to let you go so that you could render his services, but I'm not going to let you go there. Is there anything else that you think the board should know about your property?
Well, we're in the country, and I've had, several of us have had issues with, not that any of these folks are going to do this, but we have had issues in the country about strangers being in our area. I, in fact, didn't know I was even doing this, but I was cleaning up a meth lab on the property when I bought it. I didn't even know it. It's down there in the timber. So everybody is pretty nervous about having trucks on the property. Like I would get a call the minute somebody would come up like to survey, even while Dakota Access was suing me to get on my property to survey, I had folks coming from Willis, Texas, Hattiesburg, Mississippi, Kansas, let's see, Louisiana, West Monroe, Louisiana, where the ducks, you know, the duck boys are. And those people continue to come up and be on my property. Now, we had, for 4 times that I know of, a white pickup truck down there on E18 and J Avenue. Now, this is a little spooky. Looking at my farm with binoculars. So I told Michael, my cousin's boy, Michael, I said, Michael, I said, who is that? I said, we're gonna see what's happening here. So I took my pickup and drove down the road and went uptown, had a cup of coffee, and left Michael he put his truck in the garage, in the shed. And within an hour, we had somebody there to survey those people from Mississippi. Within an hour. So they would wait until I would leave, and then I'd turn around, and we did that twice, and they showed up both times within an hour, hour and a half. So I don't think they really respect private property. And that's another reason I don't really want to deal with them. When I go to Texas, I spend money, but I respect private property. When they come up here, I encourage them to spend all kinds of money, but respect private property. I think that's fair enough. It bothers me. Another thing that bothers me, and it should bother you 3 too, they have taken a long shot on this deal like this thing's going to be approved. I don't think it should be approved. They've got pipe. They've bought easements. They've spent a lot of money on a long shot deal. And I'm not so concerned about these people over here or the level of corporate people above them. But I am a little concerned about that 3-4 levels higher, what they might do, because there's a lot of money at stake on this deal. I think I should probably quit there. I don't want you to get tired of me.
You mentioned that you have some timber. Does the proposed pipeline cross any creeks, timber?
It crosses put the plat book up there again. Put your hand right up there, right above the V, right above the R on my name. Yeah, up a little further. There is a little pocket up there on the corner, and there's kind of a swale that comes down to the intake on the end of this pipeline. Okay. And then there's another swale that comes in. You see where it says 49 up there? I believe it says 49 acres. A little bit to the left of that 49 acres, it comes, it's a little swale, so it is kind of a waterway, yeah.
Okay.
Yeah.
So those are what you would call waterways, and you mentioned timber as well. But the pipeline doesn't cross any of the timber that's on your property? Okay.
The timber's all up in the northeast corner where the outlet of those 2 tiles are.
Okay.
Mm-hmm.
Thank you very much.
You bet.
Mr. Johnson, I just want to know on your 59 acres?
Mm-hmm.
So it appears that it's a clip and then it's a voluntary on the other side. What is there that they can't go further into the voluntary easement and off your property? Is there something located there, or do you know why?
Well, there's a little timber neck that comes up there, but they could easily go through. They could even go on the north side of Larry's. This is all, put your hand up there. So that 49 acres, see, is basically basically all tillable except right down there in the southeast corner, there's a little bit. And then if you go across the road, it's pasture.
All right, go back to the county. I want to go back to the H. It's easier for me. So I know that that's your 59 acres, and right above your property then is the 49 by Mr. Ferry.
Ferry, yeah.
So you see Ferry. So on Mr. Ferry's property, you see where it's clipped on your 59 acres? It's right there. What I'm curious of is why it's not simply over onto the voluntary easement. I don't
know why either. There's a little bit of a dip there. I mean, a little where our tile outlets into that little ravine or whatever you'd call it, but it's not that deep.
But it's not a natural creek or a natural waterway right there or anything?
Well, it's a natural, natural ravine. I mean.
Mr. Prey?
Just for completeness, there is an exhibit number 4, which shows a better shot of the 24-inch excavation and the soil piled. Mr. Johnson, does this photo show any, I'm not saying it does it show some of the following features? The black dirt on one side, clay on another. Is there any of this sea mud or sand, whatever it is, blue clay, yellow clay that appears in this picture?
You notice the water right down here in the bottom, the blue? We pumped that. We had to pump that all out in order to get that tile laid in there.
Is that the layer that the sand's at?
Yeah.
And is there any topsoil in this picture?
Topsoil, what?
Is there any topsoil visible in the picture?
The topsoil's to the right, the black soil.
And the soil below the topsoil, is that visible?
Sure, subsoil.
Where's that in the picture?
It starts right there, right at the hand.
Okay, is there any, what's
you
in
can
the,
see there's just a little bit of black on this side over here that gives you an idea where this is all dozed off, so we had a little bit of intermixing.
Now, you were asked a question about timber. Is that some of the timber show up in that photo?
Yes, right back there in the background.
Now, do you actually, you were talking about playing some games with the people in the white pickup or something. Where do you sleep on this property? Is there a building there that you live in?
There's a Morton building, yes, with living. Yeah, it's got living quarters in it, and that's right there. You can see part of the roof.
Okay. What's that pile? And I don't know the answer to this question, but what's all that stuff way off in the distance? Looks like it's a light-colored stuff.
Objection, Your Honor.
Well,
this is beyond the scope. I understand that.
I'm about done.
I understand the scope of cross ended up being very large, but this is
Mr. Blinsky, I agree with you.
All right,
got caught up in the moment. Mr. Prey took advantage of us getting caught up in the moment. Mr. Prey, do you have anything that's related to his prior testimony?
I guess I'm trying to figure out if that's sand back there.
That's another issue with that sea mud.
That's what okay, sea mud.
Yeah.
That's all I'm going at. Just that stuff's out there.
Watch the table.
Oops.
I don't believe I have any other. Oh, who is that gentleman standing there?
Mr. Johnson, that was his conclusion. Thank you very much.
I have one more thing. I have a well right on the southwest corner of that building, which is very near to where this pipeline would go through.
So there's a well on the property. We will add that to the notes.
Very good.
Thank you.
I believe that other than a cleanup question on what exhibits, whether there's been any actual ruling on the exhibits or if that's necessary, I don't think I have any other witnesses. If I do, and I forgot, I went through 8. I only had 8, but
I think I think we've completed your list.
All right.
On the exhibits,
I have Rasmussen 1, Rook 1, 2, and 3, Johnson 1 through 9,
were your
Merriman Anderson
exhibits
1 through
with
2.
the testimony?
Yes, they were.
All right, then they are admitted.
All right, just want that on the record. Thanks. I have no further witnesses.
Mr. Johnson, you may step down.
Thank you.
I don't. Mr. Wells, would you mind putting the mic on?
Your Honor, just are we, just for planning purposes, are we planning on taking a break for dinner soon?
You didn't have this?
We're gonna go off the record here, but you don't need to go off the record there. Here's what, Mr. Wells, you can sit down for a moment. The discussion we've been having, one, we want to get Mr. Hannigan's ruling out. So whatever we decide, we want to try and get that out this morning or this evening. And second, we were debating whether or not to handle Mr. Mahmood's confidential, since it was the end of the day, since everybody was going to be leaving, and take care of that. I don't know whether I want to go out of order or not. So I guess I would ask Mr. Pauly, are you going to have any questions that are confidential in nature?
Yes, we will.
Are you wanting to take your cross-examination out of order so that, I mean, can you do your confidential and then do you mind coming back then on Monday for the remainder?
Yes, we can do that.
Okay, does anybody have an objection with that? Mr. Mahmood, here, you don't have a choice in the fact that you're coming back Monday, because the board does not believe that we will get through our questions for you, so we know you're coming back. I am planning on doing your confidential if there was no objections, and there are none unless Mr. Dublinsky objects.
A question, Chair.
Mr. Piazza.
Would Mr. Mahmood then be testifying in open session at some point?
Yes, because the board has not asked him our questions yet.
Very good.
And they are substantive.
Neither has OCA.
And neither has OCA.
Madam Chair,
Mr.
do we have any idea how long we're going to run tonight?
I'm going to make up my mind when we get done with Mr. Wells.
Okay.
And so I haven't decided yet. I want to talk to the other board members. We're going to take a break. I want to get through Mr. Wells first.
Okay. Thank you.
Mr. Wells, can you please stand, raise your right arm? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may be seated. Mr. Wells, please state your name and address for the record.
My name is Chris Wells. I live at 22905 Great River Road, LeClaire, Iowa.
Did you file with the board prepared written testimony?
Yes.
Do you have any changes to your testimony?
No.
Do you wish to adopt your prepared testimony today?
Yes.
Your testimony is admitted. Did you file any objections in this docket?
Yes.
Do you have any changes to your objections?
No.
Do you adopt your objections?
Yes.
Your objections are admitted. Do you own any property that the proposed pipeline will cross?
No.
Mr. Lozier?
We have no questions.
Mr. Piazza? Mr. Dublinsky?
No questions?
Mr. Pauly?
No questions.
Ms. Jacobs?
No questions.
Mr. Wagner? I have no questions from you, Mr. Wells.
Okay.
You may step down. The board will take a 5-minute recess. Mr. Hannigan,
Yes, good evening.
the board chair wants to know on paragraph 4 of your reply to Dakota Access LLC's resistance that was filed on December 2nd, if were you listening to the proceedings? Where did you get the information that's in paragraph 4?
The information is secondhand information from me that came from other counsel.
Mr. Murray? Yes. Mr. Murray's co-counsel for several individuals, so I immediately went to him.
I can neither confirm nor deny that Mr. Murray called me about this information.
Mr. Murray, of the 4,000 pages of transcript that we have currently, to go back and find out, my recollection, this is related to a conversation we had about the board asking questions of the landowners, but I'm trying to recollect.
Yes, Your Honor. I think it is an overgeneralization in paragraph 4. I think that the chair had announced that the board was going to allow intervening parties that were landowners, and I was then trying to find my notes on that, and I'm having a difficult time finding that. I know I wrote that down, but you announced that intervening landowning parties would have the ability to provide supplemental testimony concerning their parcel.
Do you believe it was supplemental testimony or it was in response to board questions and the board question sheet that we've prepared?
That is the word I'm trying to find, okay?
My recollection isn't as good as it would be on Monday morning, on Thursday at 6 p.m. And I don't want to make a ruling when my recollection is this is not the context that I said that. My context was, if they're here, we've got them on the schedule to testify, the board's going to be asking these questions. But I was curious, because I am not going to ask them to get that part of the transcript done. So if you don't recall, and I don't recall, that answers that question. You
As
don't
far
recall-
as the context,
Yes.
I'm sorry, I can't recall.
Your Honor, may I comment?
Yes, Mr. Dublinski.
I certainly don't recall anything as broad as number 4, and to the extent that I recall that general subject, my recollection is certainly much closer to what the chair just discussed, that there has never been a contemplation that I recall of letting people who had not filed any sort of testimony and had not been intervened in time to be full participants in the case. I just want to make absolutely sure I don't, risk Mr. Putney think I'm directing this at him. But having an opportunity to sort of come in from scratch, if you will, and offer testimony about their land. I don't think that was ever the context for any such ruling from the chair.
Your Honor, a resolution of this question would be simply to schedule Mr. Johnson for testimony at some point on Monday, which he's willing to do.
Well, Mr. Hannigan, see, that complicates matters even further because we've had a request for a supplemental filing on another witness who we waived in, and that doesn't help. But thank you for the offer.
Madam Chair,
Mr. Puntini?
I have been doing quite a bit of note taking. If we could have till Monday, I can go back and look at my notes. And if that would help
I
you,
need to, I'm going to issue a ruling at some point. Has Mr. Hannigan signed the confidentiality agreement?
I have not.
I don't believe so, no.
Madam Chair, I think we're missing one word here and that might help clarify this. And it is my recollection that on the 23rd, when we talked about this and when there was some discussion about allowing the joining in the suit, this should have been stated to say intervening landowners only to testify, not landowners in general to testify. And the question then became a discussion about allowing Mr. Hannigan and his client to intervene, which was done, I believe, at that point in time. I do not think you allowed or ever intended to allow all landowners, but I think you did state that intervening landowners particularly.
Well, Mr. Puntini, we granted intervener status on November 13th. By a written
Yes,
order.
I understand that.
So here's my, do you have anything further?
No, I'm sorry. Thank you.
No, you're. So the board, the Iowa Utilities Board is denying the motion. However, we will take the affidavit as an offer of proof in the record. And we are taking no stance on the provisions in the affidavit, other than we do believe that is a legal issue, and you have the ability to brief that legal issue for your client as an intervener. Do you have any questions?
I do. In terms of accepting the affidavit as an element of proof in the record, then are you telling me that the affidavit is entered into the record as a true and correct fact, or at least assumed to be as true and correct as the affiant has made it?
We are taking no position on whether or not the information in the affidavit is factual or not.
I understand. However, it's in the record.
It's in the record
As an offer of proof, not as evidence in the case.
as an offer of proof.
Well,
As I understand it, then that allows you to argue your legal issue in the brief, which you still have the ability to file with the utility board as an intervener on behalf of your client.
In terms of making that argument, however, that allows Mr. Dublinsky to object, I think, at district court about that factual issue.
But it preserves Mr. Hannigan's error on that issue.
The motion, the request has been to either accept the affidavit into the record, which I understand that we just discussed, and the motion was also as an alternative to accept Mr. Johnson's testimony, direct oral testimony, that is, into the record. Or so are you telling me that you're denying his oral testimony as well?
Your client had the opportunity, just like any other landowner or witness in this matter, to file written testimony. When we allowed the intervention after the date, because the court proceeding had occurred, the motion came in, we authorized intervention at the late date. At that time, the choice could have been made by your client, just like it was with the other two individuals, to file written testimony. Your client chose not to do that.
The decision of the district court was on October 20, which was after the date to file written testimony. The other two parties had filed their written testimony in Mr. Murray's case prior to that date, which is my issue here. Is I think the district court would be surprised if, after the invitation of the board in briefing to allow and invite intervention, the court then sent the plaintiffs to the Iowa Utilities Board, and the Iowa Utilities Board allowed the intervention, but did not allow them to make their arguments subject to the intervention because of a simple fact, a single simple fact.
Your Honor, I think Mr. Hannigan just made my point when he admits that two of the clients represented by other attorneys did exactly as the chair noted. There is truly no reason and no excuse why Mr. Hannigan's client could not have followed the well-known procedural order. I understand the timing of the district court order. That didn't stop other people from filing testimony, including other parties to the Cherokee County case. The idea of having new oral testimony, which no one else has been allowed, the board has been clear in multiple orders that you have to pre-file. If we open that door on Monday, what's to stop dozens of other people? We may file another dozen witnesses. Who knows? That's just a door that has been firmly locked. We're at the cusp of the end of the hearing. It's just crazy to think about opening that now.
I think there's a set of facts here that's needs to be considered and in play. And that was that this proceeding went through a court proceeding, was recognized, and
Your Honor, this is neither Mr.
Would you let me finish?
This is neither Mr. Puntney's motion nor his resistance.
Sorry, thank you.
May I offer an additional, I guess it's a question. We believe that there was another witness, a Mr. Tweedy, who provided testimony without having previously filed testimony.
Your Honor, for starters, Mr. Tweedy timely objected, so his rights may be reasonably different. But second, while he filed in not the standard form for testimony, he did file an objection timely prior to the testimony deadline. He was here on the schedule, and it was admitted. That is not the same factual situation. And actually, while it was filed as a no...
Mr. Hannigan, for Mr. Tweedy, you can try again. but for Mr. Tweedy, I have filed testimony for him. It wasn't in the appropriate format. For some of the pro se litigants, we have worked with them in order to address filings, and in some cases where they're not exactly to form, to ensure that we're providing everyone with the appropriate due process.
We're only asking the board to work with us on this question.
And I believe that I've clearly set out for you the order of the board.
I understand.
The board is also issuing an order on a motion to allow supplemental direct testimony of W. Dale Den Herder on behalf of Double D Land and Investment LLC, and are denying the motion. Mr. Den Herder's testimony has been waived and is part of the record. The supplemental testimony will not be. The Iowa Utilities Board will be recessing until 8:30 on Monday morning. On Monday, we have a schedule of witnesses. I would like to know from the parties. I want affirmation that all of those individuals will be available for testimony on Monday. Mr. Lozier.
Yes, our witness will be available, and because of other commitments, we prefer that he be first up, and I expect it will be brief.
Who has Mr. Eberhart? Mr. Murray?
And if Mr. Murray can't, I know that I can, so. Mr. Eberhart filed something just short of a withdrawal, but said he was not going to present testimony on behalf of Keep Farms. Is that consistent with?
So that witness can be removed?
Correct. And my understanding, and Mr. Murray can correct me if he disagrees, my understanding is that it was the intent not to enter that testimony into the record.
Do we have anything on record?
You do. He filed a motion a couple of days before the hearing started, I believe, or a notice. Might have been called a notice.
I will ask Lois to try and find that. And Mr. Murray, will you just go through and read the names so I can hear them once before Monday?
Absolutely. The names are Goebel, Hickenbottom, Lamb, Lambert, Jesse. The next name is Kunz, okay. Lenhart and Smith.
And Mr. Dublinsky?
Yes, Your Honor. Mr. Mahmood can be here at 9 o'clock and is available the entire day and as far into the evening as we need. He is not, however, available on Tuesday.
I hear that. All right. We will recess until Monday at 8:30 a.m.